Good morning, sir. Can you see and hear me?
Yes, I can. Thank you.
Thank you very much. This morning we're going to hear from Mr. Andrew Parsons.
Yeah.
Repeat after me. I do solemnly,
I do solemnly,
sincerely and truly
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you, sit down.
Thank you. Can you give your full name, please?
Andrew Paul Parsons.
Mr. Parsons, you should have in front of you a bundle containing your witness statement. Is that witness statement dated the 17th of April 2024?
It is.
It is a very lengthy witness statement, 557 pages in length. Could I ask you to turn to the final substantive page, page 557, and is that your signature?
Yes,
Can you confirm that that statement is true to the best of your knowledge and belief?
it is.
Thank you. That statement has the unique reference number WITN 103-90200, and that will be uploaded on the inquiry's website in due course. That sits alongside 1,172 exhibits, comprising 18 substantive bundles of exhibits. There's a large amount of paperwork today. I'm not going to take you to hard copies. I'm going to try and deal with it all on screen, but I will be taking a note of my own in relation to a few matters as we go along. You are currently a partner at Womble Bond Dickinson.
Yes,
You began your career there as a trainee, I think in 2006, when it was Bond Pierce. Is that correct?
yes,
You qualified in September 2008 and joined the Southampton office.
yes,
You became a senior associate in 2012.
yes,
You became a partner in 2016.
yes,
We know from phase 4 of this inquiry that Bond Dickinson was involved in civil actions against sub-postmasters from the early time when you were qualified as a solicitor, so the early years of your qualification. We heard from, for example, Stephen Dilley, who was involved in the Castleton case. Was that something you were aware of when you qualified?
I was aware of the Castleton case.
Your main involvement in Horizon, I think, was from April 2013. Is that correct?
That's correct.
When you first started working on those Horizon-related matters, as a senior associate, who did you report to within Bond Dickinson?
Gavin Matthews.
Thank you. And in terms of the post office, who were your main points of contact at that stage?
Initially it was Roderick Williams, and then later Susan Crichton.
And what was your view as to their competence and abilities?
They both seemed like experienced in-house lawyers.
I'm going to start today by taking you to the Helen Rose report. That can be found at poll 000225598, please. This is a report that's well known to the inquiry, but I'll take you very briefly to a couple of key paragraphs in that report. The date of that is the 12th of June 2013, so soon after your Horizon work began. And it's an investigation into the Lepton branch. If we could turn over the page. The sub-postmaster in this case had denied carrying out a transaction, and there was an investigation. Helen Rose has written this report. If we scroll down, there's a section on reviewing the data. She says there, the Fujitsu logs were requested for this branch, but whilst waiting for these to arrive, communications took place with Gareth Jenkins at Fujitsu for more details to gain an understanding what had occurred at this branch. Just pausing there, Gareth Jenkins, was that somebody who you were aware of, even in broad terms, in April 2013 or thereabouts?
Thereabouts or shortly thereafter.
Questions asked and extracts from various emails in response. So we've seen this plenty of times. There are a set of questions that Helen Rose has asked and answers that have been provided by Gareth Jenkins. If we scroll over the page, please. one of the key parts for this inquiry, if we scroll down, she says, question, I can see where this transaction is and now understand the reason behind it. My main concern is that we use the basic ARQ logs for evidence in court. And if we don't know what extra reports to ask for, then in some circumstances we would not be given a true picture. I know you are aware of all the Horizon integrity issues, and I want to ensure that the ARQ logs are used and understood fully by our operational teams who have to work with this data both in interviews and in court. And if we scroll over the page, she makes some recommendations. I do believe that the system has behaved as it should, and I do not see this scenario occurring regularly and creating large losses. However, my concerns are that we cannot clearly see what has happened on the data available to us, and this in itself may be misinterpreted when giving evidence and using the same data for prosecutions. Now, you've set out in your witness statement why, in your view, this wouldn't have changed the picture very much. I think it's paragraph 84 of your witness statement. I don't need to take you to it. We can see that this report was sent to you. Could we please turn to poll 00190-324? We have an email at the bottom of the page, please, from Dave Posnett to Roderick Williams. And he says as follows, Roderick, please find associated a report from our fraud analyst, Helen Rose, in respect of Lepton SPSO. This office doesn't feature as part of our second site spot reviews. Just pausing there, by this stage, so the summer of 2013, I think you were involved in those second site spot reviews. Is that correct?
I was assisting Post Office with drafting the responses to the spot reviews.
Thank you. But the subject matter is Horizon and indeed Credence related. Could I ask that you consider the report and feed any comments back, as it could be a potential issue at some stage? In summary, the specifics concern a system reversal of a transaction following a system failure. This is normal practice, but the Horizon logs and Credence logs indicate that the reversal is an existing reversal, implying that the reversal was manually entered by the clerk/sub-postmaster. I think there's a remote possibility that this could be a problem in terms of using the data for evidence/prosecution purposes. But nevertheless, it is still a possibility. Myself or Helen are happy to talk through anything that requires explanation. If we scroll up to the top of the first page, please, we can see Roderick Williams sends it to you on the 3rd of July 2013, and he says, Andy, can you take a look at this so you can give me an overview on the phone sometime today? And he attaches there the Helen Rose report. Now, I think you've said in your statement that you don't recall receiving the report. Is that correct?
I don't recall receiving the report, no.
I mean, looking at this email, it is likely that you did receive the Helen Rose report on the 3rd of July.
Yes.
And it is likely that you considered its contents.
Correct.
You would have seen the wording at the bottom, the concerns that are raised by Dave Posnett.
I would have focused on the aspects of that report that were talking about transaction reversals, because that was the same issue that had arisen in spot review number 1 that I'd looked at recently.
I mean, the report itself is not very long. It's 4 pages. So it's likely, isn't it, that you would have read the report? I mean, it's actually 3 pages of text and 1 page of front page.
Yeah, I accept I would have read the report.
Yeah. Moving on to the suspense account bug, I think at that time it was the 14 bug, or referred to that, the number 14 because of the number of branches that it was known to have affected. Is that correct?
Correct.
Could we please look at poll 00296-703? If we start at the bottom of the first page, we can see an email from Ben Thorpe, who was he in the Post Office legal team?
He was a secondee from Bond Dickinson to the Post Office legal team.
Thank you. And in fact, that's how he introduces himself at the beginning of this email. He says, by way of a very brief introduction, my name is Ben Thorpe. I am a Bond Dickinson secondee from the Newcastle office, currently working with Roderick Williams in the Post Office's legal team for the next few weeks. We have received the attached query from the business regarding historical issues a very limited number of branches had with Horizon. Post Office intends to refund any losses caused by these issues, but not seek to recover any gains. Could you please review the letters and let Roderick and me have any comments you may have, particularly in the context of the spot reviews? If you'd like to discuss anything arising from your review, please do give either Roderick or me a call. If we scroll up, please, we can see your response. You say, Ben, Roderick, to be honest, I don't quite follow the logic of Andy Wynn's letters. I suspect this is just me, and this makes perfect sense to the sub-postmasters. The risk here is that disclosing any form of an error in Horizon could become problematic if it ends up in the hands of the Justice for Sub-Postmasters Alliance. However, we have no real option but to disclose this issue and make right the error with the sub-postmasters that have been affected. To do otherwise risks damaging the Post Office's credibility on Horizon and severe criticism from the Federation. My suggestion, therefore, is to make sure that we understand the root cause of this error before going public. Hopefully this will give us a good explanation as to why this one error does not undermine our general view that Horizon is otherwise robust. With that in mind, are you happy for me to speak to Simon Baker, Andy Wynn, to get some more background/technical details? So you say there, hopefully this will give us a good explanation as to why this one error does not undermine our general view that Horizon is otherwise robust. Were you concerned on reading that it was a possibility that general view could have been undermined?
At this stage, I didn't understand the nature of the error in hardly any detail. I was also only about 2 months into working for Post Office in earnest, so my understanding of Horizon was pretty limited. So I wanted to understand more information before forming that view.
Could we please turn now to poll 001444848? So letters by this stage have been drafted and sent to you for review. You are now responding to Roderick Williams, and you say, I've reviewed the sub-postmaster letters. I've attached markups of the two letters which show the suggested amendments that should be made across all the letters. And you set out in bullet points the various amendments that you've made. But the first, to insert an opening paragraph that explains the Post Office's investigation and highlights the fact that we have sought to protect sub-postmasters from any harm in the interim period. To remove the word problem and replace this with less dramatic word issue. Just pausing there, was that your own initiative? Was that something that you were aware of, that the business wasn't happy with certain language?
No, I'd had no instructions as to use of particular language. I think it's a fairly ordinary thing for lawyers to do, to soften wording in letters.
You say, I don't think we should apologise in the letters. I know this sounds hard, but in apologising, we are admitting some degree of culpability. I think we should maintain a more cold procedural approach to correcting what is effectively an accounting irregularity. Is that, again, something you did your own initiative without instructions on that particular matter?
Yes, these are my recommendations to Post Office.
You then say, in some circumstances, it appears that an error caused a transaction record from a former sub-postmaster at a branch to be carried over into the records of a later sub-postmaster at the same branch. In my view, this is a dangerous admission, as the complete separation between sub-postmaster records is a cornerstone principle of ensuring Horizon's integrity. Although this has happened and is completely explainable, I don't think we ever want to expressly document this. Are you saying in that final bullet point that it's such an important issue for Horizon that you don't think that it should be documented?
I'm talking here in the context of these letters which are individual letters to go to individual sub-postmasters.
And why wouldn't you want to expressly document something that is the cornerstone of ensuring Horizon's integrity?
We're talking here about these particular letters. This isn't advice to suggest that the whole issue should not be documented.
And why wouldn't you want to document it in those letters?
Because each letter was individual to each branch, each one was customised, and so it dealt with the issue in that individual branch.
But why wouldn't it matter? Why would you be concerned about expressly documenting something? Is it because you would be concerned about disclosure, for example, in other cases?
But disclosure of this issue may have come out anyway because the issue was documented in other documents. What I'm talking about here is the individual letters. Each one was customised for each individual sub-postmaster to reflect their position and how it impacted on them.
I'm not too sure how that answers the question that I've just asked, though, which is about disclosure in other cases. Were you concerned that by documenting it in these particular cases, it would then be on record to be disclosed in other matters? Was that a concern that you had that is expressed in this bullet point?
If it had been documented in those letters, then yes, it would have been disclosable in other matters. But my point being is there would have already been in existence documents about this issue.
And was a concern that you had that if you documented it, it would then become disclosable in other matters?
I don't believe I gave it that level of thought.
You were, at this time, summer of 2013, concerned about expressly documenting matters relating to Horizon integrity.
Again, this is in the context of letters to individual sub-postmasters. It's not a general observation on how Post Office should document problems in Horizon.
Can we please have a look at the letters? Could we turn to poll 001448848? Sorry, 849. It's poll 001448849. Thank you. So these are your amendments to the letters. This is to a sub-postmaster, and it says, I'm aware that you've communicated previously with our current agents team in relation to 2 unexplained discrepancies that have impacted your branch. Thanks for alerting us to the issues. So this is a letter where someone has already made a complaint and it's responding to their specific complaint.
That's what I understood.
Yes. And you've added this. You've added, in light of these discrepancies, Post Office has thoroughly investigated your branch's records, and whilst undertaking this investigation, we have ensured that any known discrepancies have not been charged to your account. I write now to confirm the outcome of our investigations. What was the thorough investigation that had taken place?
This was information provided to me by Andy Wynne of Post Office.
This was your insertion into a draft letter. What investigations had you carried out that the Post Office had thoroughly investigated the branch's records?
I had personally not carried out any investigations.
Were you nevertheless comfortable in inserting that addition?
Those were my instructions from Andy Wynne.
I can confirm, and then you speak about the gains, and then we see that you've changed the word problem to issue, and you've struck out the words by the former sub-postmaster. Is that because, as you identified in that previous email, that at the cornerstone of ensuring Horizon's integrity was the separation between sub-postmasters' accounts?
That's what I understood at the time.
And thereby, by removing reference to the former sub-postmaster, it would not be clear to the person reading this letter that that strict division between sub-postmasters' accounts had not in fact functioned on that occasion.
I think it would have been possible for the sub-postmaster to have worked that out because it mentions 2010. TP8 is trading period 8, so they would have known whether that happened whilst they were the sub-postmaster or not.
So why strike it out?
Because I didn't think it was relevant to this particular sub-postmaster.
It's not because you didn't think it was relevant. We can go back to those bullet points if you want, but you said in that final bullet point that it is my view this is a dangerous admission as a complete separation between sub-postmasters' records is a cornerstone principle of ensuring Horizon's integrity. Although this has happened and is completely explainable, I don't think we ever want to expressly document it. And surely by removing reference to by the former sub-postmaster, you are making it less clear that that separation had been violated.
I accept that.
If we scroll, could we scroll down, please? Keep on scrolling. And then, again, strike out the word problem, replace it with issue, and then strike out the apology at the end. What was the problem legally with making an apology?
I think sometimes apologies can be interpreted as admissions, and it's not. I think it's pretty common for lawyers to, in letters, to consider whether the apology is appropriate or not.
Post Office were, in this case, making an admission, weren't they?
Yes.
There had been an issue or a problem, it had been corrected, and this was notification to the sub-postmaster that that had been corrected. What was the problem in this particular case of apologising for that?
In my view, it leads people to consider that there was, as I say, an admission of legal fault, when in fact Post Office's view is yes, there had been a problem, but it was being corrected through proper channels.
And was that something that you regularly did on behalf of the Post Office?
It would depend on the circumstances.
Are there other letters where you would have removed apologies?
Possibly.
Could we please look at poll 001448850? This is the other attachment. This is the other amendment. Made very similar amendments. If we scroll down, we can see reference to that thorough investigation. Do you see, in terms of the thorough investigation, is it likely that in fact the investigation was only in relation to this particular issue that had been identified, the 14 bug?
I can't now recall.
Do you recall any wider investigation that took place in relation to these sub-postmasters' branches, investigating their branch records, any wider than the identified issue in this particular case?
I can't recall.
Would you accept that reading that letter, it sounds as though a thorough investigation has taken place that is wider than simply one particular issue?
I could see how someone could read it that way, but I also think it's read in the context of looking at a particular issue.
And where does it explain that a particular issue has been thoroughly investigated?
Because it's targeting those specific discrepancies in the accounts.
Did you draft it intentionally so that it was ambiguous as to what the investigation had been into?
I don't believe so.
I mean, for example, why wouldn't it have said the Post Office has thoroughly investigated this issue? It says investigated your branch's records. It's drafted in quite a wide way. Would you accept that?
I can see how you could read it that way. I don't believe I gave it that level of thought at the time.
Can you see how the recipient may well read it that way?
I think they would have recognised that this was investigating a particular discrepancy, and that's what was being investigated.
So it wasn't your intention to suggest a broader investigation than in fact had taken place?
Correct.
Could we please turn to poll 001448864? We're still on the same day, 27th of June 2013, poll 001448864. Thank you. It's the bottom email on that page. You email Roderick Williams and you say, Roderick, as discussed, please find attached a version of the letter for those sub-postmasters who are currently not aware of the situation. So there were letters going out to those who had actually made specific complaints, those who knew about the investigation, and then a third set of letters, which was to those who weren't already aware of the situation. Is that correct?
I can't now recall what that was a reference to.
Well, looking at this email, does it seem as though there was a further set of letters to sub-postmasters who were not currently aware of the situation?
My recollection is there were two versions of the letters, one for those who had suffered a loss, one for those who had suffered a gain. I don't recall whether there was a third version for another category.
Okay, well, let's have a look at the draft letter that's attached to this email that's sent in your name on the 27th of June 2013. That is at poll 001448854. This is the letter that was attached to your email. If we scroll down, we can see it's informing a sub-postmaster, and it says branch discrepancies at, and it names the post office. You may have been aware of two small value unexplained discrepancies that have impacted your branch. In light of these discrepancies, Post Office has thoroughly investigated your branch's records, and whilst undertaking this investigation, we have ensured that any known discrepancies have not been charged to your account. I write now to confirm the outcome of our investigations. And it refers to a small value declaration that was amended. Looking at this, is this something you recall now? Does this assist?
It appears that the first paragraph has been changed.
This isn't a change. This is one that you sent independently. You said, please find attached a version of the letter. So it's a further letter to those who weren't aware, and it refers specifically to an issue in their particular post office, doesn't it?
Correct.
Do you think it's fair to say that a reader of this letter will be under the impression that, in fact, there are two small value discrepancies and that this is effectively a business as usual type correspondence, no explanation, for example, of it affecting other branches?
I couldn't comment on whether this was a business as usual type correspondence for Post Office to send.
Well, you were drafting the letters. You were assisting the Post Office drafting the letters. If you were to read this and you were a sub-postmaster, do you think you might get the impression that you were the only one affected by this discrepancy?
You might get that impression.
Do you think you might get the impression that, in fact, it's only two small value discrepancies that have occurred?
In that branch, yes.
But you wouldn't have known about other branches, would you?
Correct.
Again, was that the intention of this correspondence to suggest to the recipient of their correspondence that it was only them that was affected and that it wasn't a big deal?
I don't believe that was the intention.
Why in that correspondence not say to the recipient, you are one of a number of branches that have been affected by this issue?
I don't believe I gave that any consideration. The instruction was to draft a letter that was focused on each individual branch and explaining their position.
Can we please turn to poll 001448871? Same day, another email between yourself and Roderick Williams. The bottom email is Roderick Williams to yourself, saying, we discussed this yesterday. You mentioned this might have been kicking around for circa 12 months. Can you give me a couple of bullet points on when this first came up and what the Post Office did next? And if we scroll up, we see your response. You say, Roderick, the issue manifested in around 2011, and those sub-postmasters that suffered sizable errors, i.e. ones that were easy to spot, reported the issue immediately. So just pausing there were sub-postmasters who experienced sizable errors.
Yes.
So the correspondence we saw before about the two small value unexplained discrepancies, alongside those small value discrepancies, there were large ones.
That's my distant understanding is there were some larger ones, yes.
However, as it was only a few branches, Chesterfield didn't see the pattern in the errors for over 12 months. It was only as more issues were raised and no individual branch by branch explanation could be found that someone, not sure who, realised that it could be an error in Horizon affecting multiple branches. I presume that it then took time to engage Fujitsu, investigate the technical causes, and determine the effect of the causes, etc. So this is a bug that occurred in 2011 that was only realised 12 months later, is that right?
I think that was my understanding at the time, based on what Andy Wynne had told me.
And we're now in 2013, summer of 2013, and you say you presume it took time to engage Fujitsu, so a considerable further period has taken place before sub-postmasters have received any correspondence on the issue, or received that correspondence explaining the issue.
That's my presumption at the time, though I just would note that my understanding of this bug is its nature was that it was annually reoccurring.
Yes.
So it would only come up once a year, which was part of the context of this.
So it happened twice before it was actually spotted.
Correct.
You say that I presume that it took time to engage Fujitsu, investigate the technical causes, etc. Were you aware of the extent to which Fujitsu had been investigating the causes?
Not at this time.
So again, if we refer back to those letters that I took you to, where you referred to a thorough investigation, in fact, you personally weren't aware of the extent of the investigation.
I was working on the instructions provided to me by Andy Wynne.
Did you question those instructions?
I remember speaking to Andy Wynne and discussing the matter, but beyond that, I can't remember the details of those conversations.
So we're still in the summer of 2013. You now, by this stage, know that there was this bug, not just that sub-postmasters' records couldn't be kept separate from a successor sub-postmaster, but it was also a bug that went on for a year without anyone noticing and took even more time to resolve. Is that right?
Correct.
So, summer 2013, I'm going to put new of the suspense bug. You were concerned about its implications for accounting integrity?
Correct.
And you had in an email raised concerns about documenting that?
I'd raised concerns about documenting in these specific letters, not generally.
Okay. Can we please turn to Poll 004-07496, please? Still in the summer of 2013, 1st of July 2013 now. Could we start on the second page? The bottom of the second page. An email from Simon Baker to Roderick Williams. Rod, it would be helpful if we can show that Horizon bugs were discussed openly in our court cases. We know that the Falkirk bug was discussed in the Misra case. Can you find out if there are any other examples where bugs have been discussed in court? And that request is ultimately sent to you. We can see that on and your answer on page 1. So if we go to the top of page 1, we can see you say, other than Castleton and Misra, we're not aware of any litigation that has involved an allegation of an actual bug in Horizon. However, this is based on anecdotal discussions inside Bond Dickinson. Just pausing there, who had you spoken to inside Bond Dickinson?
I don't recall.
Please bear in mind that we've handled hundreds of cases over the last 5 to 10 years for Post Office. So absent a case-by-case review, it's impossible to say for certain that no sub-postmaster alleged a Horizon bug. We are, however, confident that no case in the last 2 years has involved an allegation that there is a specific flaw in Horizon. Just pausing there, the first paragraph that I took you to refers to an actual bug. Third paragraph, we're talking about a specific flaw. Were those words quite carefully chosen in that what you're saying here is an actual bug that has been referred to, for example, by name or that is known about, rather than, for example, a wider problem with Horizon?
I don't think I meant any difference between those two phrases.
Well, you were aware that in that time, sub-postmasters had been raising problems with Horizon and that they couldn't necessarily pinpoint that to a specific or actual bug.
Yes.
There are a number of cases handled by our paralegal team that have been put on hold because a sub-postmaster has alleged problems with Horizon. So there are also some that are now on hold because I think Second Sight are investigating.
Correct.
These cases are suspended pending Second Sight report. It may be that on closer inspection, these cases reveal a specific complaint about an error in Horizon. However, we would need to undertake a deeper review of each case to determine this. On Castleton, I've spoken to the lawyer who conducted this litigation, which took place in 2007. Can you assist us who it was that you spoke to?
I can't recall, but I believe it would have been Stephen Dilly.
The case was principally about accounting records. The Horizon challenges by Castleton were generally uncoordinated and piecemeal. It should be borne in mind that Castleton was unrepresented, so there was no logical attack on Horizon. And you say, I'm still looking into Misra and will report back soon. So can I add here to my list of things in summer of 2013 that you knew about the Castleton case, you knew in broad terms, although not the specifics, about the Misra case, and you knew that other cases were on hold because of Horizon challenges?
I think I knew both about those cases, and I think the other cases were generally all paused because the Second Sight work was going on.
And you knew that they were paused because they were raising concerns about the integrity of the Horizon system?
That's what it says there, but I can't recall that now.
Second Sight's interim report is then the 8th of July 2013. I'm going to take you very briefly to that report. The inquiry's seen it many times. It's Pol 000999063. Thank you. And if we turn to page 6, please. We see there the bugs that are referred to they're referred to as defects in the Second Sight report. The first is the receipts and payments mismatch problem impacting 62 branches. The second is the local suspense account problem. That's the 14 branch issue that you had already been dealing with.
I'd been drafting the letters on.
6.10. There's also another bug. I think that's the Calendar Square Falkirk bug. It says Pol has informed us that it's disclosed in witness statements to English courts information about one other subsequently corrected defect or bug in the Horizon software. And that was, in fact, the issue that you were looking into on behalf of Roderick Williams, wasn't it? You were looking into whether there were other bugs that had been disclosed in court cases.
Correct.
And Misra was one that you were going to come back to him on. Presumably you did come back to him on Misra?
Yes, I believe we had someone review the case.
Yes. Because I'm going to add, we're in the summer of 2013, 8th of July, at least 3 bugs known to you.
I knew of 3 bugs. at that time.
Yes. Cartwright King's advice on Gareth Jenkins now. That was dated the 15th of July 2013. You've dealt with it in your witness statement, paragraph 87. Could we please start with WBON 40133? And if we could start on page 4, please. Bottom of page 4, 16th of July 2013. Susan Crichton emails you. And she says, Andy, we received a letter from the CCRC, Criminal Cases Review Commission, yesterday, which I have asked Cartwright King to review. Their advice feels odd to me, as if given on a take-it-or-leave-it basis, and I'm not comfortable that's particularly useful in this context. Could we discuss? I'm happy to go to another firm that specialises in criminal law or a barrister. Somehow it feels as if there's a conflict here, which I'm not sure I understand. Over the page, page 3, please. There's advice given by Gavin Matthews. So he was your supervising partner, was he, at this stage?
Correct.
And he says, I know that you are with Simon and Andy today, so I've taken an initial look at this for you. On the 16th of July, is Andy a reference to you? Were you meeting with Susan Crichton on the 16th of July?
I think that is a reference to me, but I don't recall that meeting.
He says, I agree with you that I would expect the advice to me to be more prescriptive, i.e. you need to say this in response. I do also have concerns from a civil point of view over a couple of statements in the draft response. So this is the draft response to the Criminal Cases Review Commission that had been drafted by Cartwright King. And he says, in particular, where it states, he has done so both to the Post Office and in expert witness statements and oral evidence to the court. In particular, he has attested to the presence of defect detection and rectification systems, the robustness of the prosecution audit trail, and stated that, in his expert opinion, Horizon accurately records and processes all information submitted into the system. The second site interim report demonstrates that this was not the case. So that's there a reference to Gareth Jenkins, isn't it?
Yes.
Yes. And your supervising partner there is raising a concern about that being included in the letter to the Criminal Cases Review Commission.
Yes.
And he says, I consider this to be unhelpful, given that the second site report found there to be no systemic problems with Horizon. It shows the need for all post office letters, criminal and civil, to contain a consistent message, so that the right hand and the left hand know what they are each doing. Were you aware that that was the advice from your firm, that there needed to be greater coordination between the criminal and the civil sides?
I was copied to this email.
Yes, so you were aware.
I was aware.
Not just from this email, but perhaps from conversations with your supervising partner?
I don't believe before this point my firm had any involvement in the criminal side, so there may have been no conversations before this email was sent.
So from this point on, the approach of your firm was, and the advice to the post office was, that we need to coordinate more between the criminal and the civil side.
I think that is an early comment from Gavin, which will have been the first time we've been asked to consider the crossover between the civil and criminal side. And as he goes on to say later down, he notes he's not a criminal lawyer and he suggests that they get advice from a criminal barrister.
Could we turn, please, to the first page? There's another email from Gavin Matthews. You were presumably at this stage very much aware of the Gareth Jenkins issues because you were meeting Susan Crichton that very day.
I think I'd been informed a few days earlier that there was something to do with Gareth Jenkins, but I wasn't fully aware of the issues until I received a copy of the advice from Cartwright King.
Thank you. And we'll go through that advice shortly. So Gavin Matthews emails Susan Crichton and says, Susan, I thought I would give you my preliminary views on this pending our call. Were you involved in a call on that day? I know you met her, I think, on the 16th. Were you aware? Do you recall a call the next day?
No. At this time, I was mainly focused on looking at the response to Second Sight, because their report had just been published.
The Post Office needs to look at the response to the CCRC in the context of the overall strategic advice received from Cartwright King, including their advice regarding Gareth Jenkins / Fujitsu. If the Post Office suffers losses directly referable to Gareth Jenkins' failure to comply with his obligations as an expert witness, there are 3 potential entities against whom the Post Office may have an action: Gareth Jenkins, Fujitsu, and Cartwright King. 4 is, given that Cartwright King are potentially liable to the Post Office for any failure on the part of Gareth Jenkins / Fujitsu, I do think it would be sensible to get a criminal QC to oversee the strategic advice being given by Cartwright King. I'm not saying that Cartwright King have definitely done anything wrong, but they may have done and are trying to blame Gareth Jenkins / Fujitsu. So it's very important to check that their tactical approach is now overseen by someone completely unbiased. And we'll see in due course advice is sought from that criminal QC. We'll look at that advice. Could we please first, though, turn to WBON 40770. If we scroll down slightly, we can see that Martin Smith sends Susan Crichton the Simon Clark's advice on Gareth Jenkins. And if we scroll up, please, we can see that Susan Crichton sends you the advice. And that's that same day, 17th of July, 2013. Can we please turn to the advice? And that is poll 00006357. This is Cartwright King's advice, the Clark advice on Gareth Jenkins, entitled Prosecution's Expert Evidence. Could we please start on page 5, paragraph 14. Expert evidence relied upon by the Post Office in prosecuting offences. For many years, both the Royal Mail Group and latterly the Post Office has relied upon Dr. Gareth Jenkins for the provision of expert evidence as to the operation and integrity of Horizon. So you were aware at this stage that it had been relying on the Post Office had been relying on Gareth Jenkins for a number of years to provide expert evidence.
That's what I took from this advice.
Yes. Paragraph 15, Dr. Jenkins had provided many expert statements in support of the Post Office and Royal Mail Group prosecutions. So lots more than one, plenty of, a number of different expert statements.
That's what it says there.
And was that your understanding?
Yes, having read those words.
Thank you. Could we turn to page 13, please? We have the conclusion. Paragraph 37, what does this all mean? In short, it means that, and that should read Gareth Jenkins, has not complied with his duties to the court, the prosecution, or the defence. Paragraph 38, the reasons as to why Gareth Jenkins failed to comply with his duty are beyond the scope of this review. The effects of the failure, however, must be considered. I advise the following to be the position. Gareth Jenkins failed to disclose material known to him, but which undermines his expert opinion. This failure is in breach of his duty as an expert witness. Accordingly, his credibility as an expert witness is fatally undermined. He should not be asked to provide expert evidence in any current or future prosecution. If we scroll over the page, please. We see there that first bullet point on the page. It says, by reason, not least by reason of Gareth Jenkins' failure, material which should have been disclosed to defendants was not disclosed, thereby placing the Post Office in breach of their duty as a prosecutor. By reason of that failure to disclose, there are a number of now convicted defendants to whom the existence of bugs should have been disclosed, but was not. Those defendants remain entitled to have disclosure of that material, notwithstanding their now convicted status. And the next bullet point. Further, there are also a number of current cases where there has been no disclosure where there ought to have been. Here we must disclose the existence of the bugs to these defendants where the test for disclosure is met. A very serious advice, one that you presumably took very seriously at that time.
I read it, but this was within the remit of the criminal lawyers to deal with.
But it's not just dealing with the existence of bugs that we've already seen, you were aware of throughout the summer of 2013, but by now, potential miscarriages of justice. Was that not something that played on your mind at all?
It was a serious matter, but it looked like to me it was being addressed by Cartwright King, and then subsequently Post Office understood the seriousness, which is why they brought in Brian Altman.
There were sub-postmasters who had been convicted on the back of that evidence. Presumably, irrespective of your day job, you were concerned about that.
I could see the seriousness of the matter.
Could we turn to poll 000-83932, please? This then sets in motion a number of different actions, one of which is this regular call regarding Horizon issues. Do you recall those regular calls?
I recall the calls as a concept. I don't recall any of the individual ones.
Well, here we have the first of those, which was presumably significant in the sense that it was the very first. 19th of July 2013. You are named as an attendee. Do you recall attending that first regular call?
I don't recall attending that call, but I have no reason to doubt that I was there.
There are two entries from you that are recorded in these minutes. Can we please look at the first, which is on page 2? It says, Andrew Parsons commented on the need to limit public debate on the Horizon issue, as this may have a detrimental impact on future litigation. Over the page, please, to page 4. Second entry on page 4. Andrew Parsons stated all lists and spreadsheets should be sent to Rosie Gaisford for collection, spoke about emails, written comms, etc. If it's produced, it's then available for disclosure. If it's not, then technically it isn't. Is that accurate?
I don't believe this minute is a verbatim record of what was said. And so I suspect some of the context or wider language used has been lost somewhere. I don't think it would be unsurprising for me to have given Post Office advice on what its civil disclosure duties might be, and that's what's being given there.
And do you see the civil disclosure duty to be, if it isn't produced, it's then available for disclosure? If it's not, then technically it isn't?
This is talking about the fact that in civil rules of disclosure attached to documents, which is information that's recorded.
Can you see that it might be interpreted as advice that people shouldn't be writing things down?
No.
Martin Smith has given evidence to this inquiry, and he said that you also spoke at the beginning of the meeting after Rob King, and you raised concerns about difficulties which could arise following circulation of minutes. Do you recall advising of concerns about the circulation of minutes?
I don't recall advising on minutes at all in these meetings. These calls were set up by the criminal lawyers, and they were driving the process.
Could we please turn to poll 406799, please? This is a contemporaneous piece of advice from Cartwright King. It's what we know as the shredding advice, or what's been referred to as the shredding advice, disclosure, the duty to record and retain material. And it says over the page, please, it summarises the information that's been given to Mr. Clark. It says, at some point following the conclusion of the third conference call, which I understand to have taken place on the morning of Wednesday the 31st of July, it became unclear as to whether and to what extent material was either being retained centrally or disseminated. If we scroll down, please, to point 3, he summarises the various bits of information that he's received, and he says, advice has been given to POL, to the post office, which I report as relayed to me verbatim. If it's not minuted, it's not in the public domain and therefore not disclosable. If it's produced, it's available for disclosure. If not minuted, then technically it's not. Again, those are the words in effect that we saw in those minutes a moment ago. This is a contemporaneous document. It was drafted, written on the 2nd of August 2013. That sounds very much like the advice that's attributed to you in that first meeting. Do you agree with that?
No, I think the wording is different between the two documents. And as I say, I didn't produce those minutes and I didn't approve those minutes. I don't think something's been accurately recorded in them. To be clear, I never advised Post Office that they should not minute those calls. And until the suggestion that there was some connection between what I had said and this advice was raised in this inquiry, I had no idea that there was any connection with anything I'd done.
There is a body of evidence that the inquiry has seen that suggests that your advice to the Post Office was not to keep a paper trail.
I disagree. I did not advise Post Office against minuting those meetings.
There is some evidence that you advised caution in minute taking. Do you agree with that?
In the context of this, I did not advise Post Office not to minute those calls.
Do you think that those who were present at meetings with you could have got the impression from the advice that you were giving at those meetings that they should be careful about writing things down?
I think they would have got the impression that they would be subject to disclosure duties, which is what I'd advised them. Had I said something to the effect that all could have been interpreted to mean that they shouldn't be taking minutes, I would have expected Martin Smith from Cartwright King, who was on those calls, to have said something, and nothing was said.
That can come down, thank you. Do you think that you gave advice to the Post Office that they shouldn't write things down because they would be disclosable?
No.
Could we please turn to poll 0014576? This is an issue we're going to come back to, but given your answer just now, I would like to give you the opportunity to address it. If we start on page 4, please. This is around the same time, July 2013, 24th of July, the bottom of page 3. Sorry, page 4. Susan Crichton emails you and says, Andy, could you take a look at this draft letter to go to our insurance broker regarding the Horizon issue? I've not looked at it. Your response is above. You say, the letter does nothing more than put the Post Office's insurers on notice of the Horizon issues. It's very bland. My only hesitation is whether it's strictly necessary to do so. From a PR perspective, it would look bad if this got into the public domain, sign of guilt/concern from the board. I'll be happy to have one of our insurance lawyers look over the D&O policy to see if the Post Office is required to notify the insurers. If not, then we might want to hold fire on this. I would recommend tweaking the first paragraph. The current version suggests there are problems with Horizon, when at present there are no systemic problems to report. Over the page, please, can we go to page 1? There comes a time where you've spoken to the lawyers who looked over the D&O cover. You say as follows, I've spoken to one of our insurance lawyers regarding the D&O cover. And it's the last 3 paragraphs I'd like to look at. You say, the risk of notification is that it will look bad for the Post Office if it ever became public knowledge that the Post Office had notified its insurer. To reduce the risk, it is recommended that rather than sending a formal written notification, the Post Office speaks to Chartis, renamed AIG, and verbally notifies them so as not to leave a paper trail. In our experience, AIG may be prepared to accept a verbal notification. Post Office should make expressly clear to AIG that the notification is subject to litigation privilege. This should help protect against disclosure under the Freedom of Information Act. Are you not there in July 2013 giving advice to the Post Office that they shouldn't write something down, that they should communicate it only verbally?
In the context of this insurance point, but earlier we were talking about the minutes of those calls.
My question was much broader earlier. I said to you, have you ever advised the Post Office
In which case
not to write something down? And here we are, July 2013, precisely the same period in which that advice is attributed to you. Doing exactly that, aren't you?
In which case I apologise because I misunderstood your question. I thought you were asking it in the context of the minutes of that Horizon call.
So you are accepting that in July 2013, at the same period of time, you did advise the Post Office not to communicate in writing to their insurer, not to notify their insurer because that would become disclosable. But for some reason, the minutes that are attributed to you regarding very similar advice, those are wrong, are they?
I don't accept it was very similar advice. The advice that was recorded in those minutes, which, as I said, they're not verbatim minutes and I'm not sure of their accuracy, simply records the position that documents need to be disclosed if they're created. This is talking about a different matter, which is communications with the insurance company. And actually, ultimately, off the back of this, a written notification was provided to the insurers.
Yes, but your advice in July 2013, the same period in which this first Horizon weekly call is taking place, was don't notify something because it will be disclosable. Isn't that the advice you are giving in relation to minutes on the 19th of July 2013?
No, they are two separate pieces of advice in different contexts where I say different things.
They are remarkably similar, though, aren't they?
No, I don't believe they are. I think the first one is talking about the disclosability of documents. It doesn't say anything in that minute about me saying that minutes should not be kept or documents should not be produced. And then we're now 10 days later talking in a different context about insurance issues.
But it's the same point, that if you write things down about Horizon, about problems with Horizon, it might become disclosable.
But that's
You
correct.
shouldn't do that.
Apologies. That's correct.
That is correct.
Well, that is the state of the law. If you write documents down and you create documents, they can become disclosable.
And therefore, you shouldn't create such documents.
I disagree.
But that is, in fact, what you're advising in relation to the insurance.
As I say, it depends on the context in which the question is put.
Okay, let me take you to your explanation in your witness statement. So it's WITN 103 90200. Thank you. It's page 64. Paragraph 105. You say as follows: I do not understand the reference to produced in the comment that is attributed to me. The word produced is not a word I would ordinarily use in this context. I think of the word produced in the context of running a production of documents from a data room, which is a technical e-discovery process, which are then given to the other side in civil litigation as part of disclosure. I would not use the word when describing the creation of new documents by my client, which are then potentially disclosable. The use of this word suggests to me that the note is not an accurate record of precisely what was said. So I'll just repeat the words that are in the minutes. It is spoke about emails, written comms, etc. If it's produced, it's then available for disclosure. If it's not, then technically it isn't. And your explanation in your witness statement is, that doesn't sound like me. I don't use the word produced in that context. Is that right?
I generally don't. I consider it in the context of running productions of documents.
That's quite an elaborate explanation, isn't it, that's set out at paragraph 105.
No, I think it's also reflecting, if you look at the minute, it's clearly a short précis of what was said. It doesn't stand to be a verbatim minute. And therefore, I think there is probably some inaccuracy in the minute taking.
And your basis for saying that the minute is inaccurate is, amongst other things, that you don't use that word in that context.
Amongst other things, but also reading the minute as a whole, I think it's obvious that it's not a verbatim minute.
Can we please turn to FUJ 000-81921? The context of this email does not matter for now. This is a 2019 email. But let's just have a look at that middle email. It's an email from you. You say as follows: Pete, Matthew, Dave. As part of the court process, the experts on both sides have to meet to try and agree a joint statement on the key issues in the case. This has resulted in them producing 4 joint statements. These statements are produced without the involvement of the legal teams, hence why we haven't sent these over to Fujitsu for comments before now. Could we turn please to poll 00253345? Poll 00253345. Thank you. Another email from you. Again, context doesn't matter. Turn over to the 3rd page, please. There are points there. The draft order also sets out our proposed directions to the March 2019 trial. These split out into 4 phases, and then we look at phase 3. The experts produce their principal reports into Horizon. Phase 4, supplemental reports are produced in light of anything coming out of the Common Issues trial. Could we please turn to poll 0000444? Sorry, maybe 5 zeros. Poll 5 zeros, 3 fours. It's coming up. Your witness statement in the Alan Bates case, 4th witness statement, if we scroll down. Could we please turn to page 24, bottom of page 24, of your witness statement in those proceedings, paragraph 117. You say in the second half of that paragraph, if we scroll down slightly, you say, to attempt to locate all of the training materials, Post Office would need to contact all trainers since 2000 to understand what materials were produced and where they were kept. That's a witness statement to the court, verified by a statement of truth. Do you want to revisit that part of your witness statement in these proceedings, which said that the word produced is not a word that you would use in that kind of a context?
I think my statement says I would not ordinarily use this word. I clearly have used that word on occasion.
Do you therefore want to revisit whether that minute reflects the advice that you gave to the first of those meetings? That if it's produced, it's available for disclosure. If it's not, then technically it isn't.
I still believe that that minute is not a full and accurate record of what was said in that meeting. I think you only have to read the minute to realise it's not a verbatim record.
And is it still your position, therefore, that you didn't advise caution in relation to the creation of minutes because of their potential disclosure?
I did not advise Post Office against minuting those meetings.
Thank you. So I think that's an appropriate time for our first morning break.
All right. Yeah.
Come
What time
back
should we
at
resume?
5 minutes past 12, please. Past 11, sorry.
All right. Yes. 11:30 it is.
Thank you. Thank you, sir. Can we please move on to WBON 4037s? We're still in July 2013, 23rd of July. If we scroll down to the bottom of that first page, you are, by this stage, involved in corresponding with the Criminal Cases Review Commission. You say, Susan Jarnail, so Susan Crichton and now Jarnail Singh, that wasn't a name you mentioned at the beginning. He was a criminal lawyer at the post office.
Yes.
And you're now liaising with him. Please find attached a draft holding letter to go to the Criminal Cases Review Commission. The letter probably needs to go from Paula. This letter just holds the current position until we have spoken to Brian Altman tomorrow. Brian Altman, Criminal Counsel. So we're now liaising with Post Office's criminal lawyer and making reference to Criminal Counsel, who's going to be advising on the Cartwright-King processes, etc.
Yes.
Could we please have a quick look at that letter? It's poll 000-99346. So this wasn't just a holding letter in the sense of we'll get back to you. There is some substance in the response. Could we scroll down, please? This is 23rd of July. You're meeting Brian Altman the next day. It says, and it's in reference to the Criminal Cases Review Commission who wrote to the Post Office. We've seen that letter. This letter briefly explains the background to the matters raised in your letter and the steps currently being taken by the Post Office. I anticipate being able to provide you with a more detailed response by the end of this week, and that's because you're going to have a discussion, I think, with Brian Altman and hopefully send a further letter. Is that right?
That was the intention.
Yes. At the centre of the Post Office's business is an IT system known as Horizon. The system is used by over 11,000 sub-postmasters. As you'll be aware, Post Office has commissioned an independent firm of forensic accountants, Second Sight. The aim of their report is to highlight any issues in Horizon. This month, Second Sight released an interim report highlighting a number of issues that required further investigation, but also reached the interim conclusion that there were no systemic problems with Horizon. The data stored on Horizon is sometimes used by the Post Office in the prosecution of criminal offences. Historically, the Post Office was a division of the Royal Mail Group. However, the Post Office was separated out on the 1st of April 2012, and each became separate and unrelated organisations. Prior to separation, it was Royal Mail Group who conducted the prosecution of criminal offences committed by sub-postmasters and or their clerks. However, post-separation, the Post Office assumed the role of prosecutor. We are now looking at Second Sight's findings in detail and are also investigating whether those findings have an impact on any historic or ongoing prosecutions. I hope to be able to send you a more comprehensive response on these matters by the end of this week. That letter ultimately went out. Sir, I'm not going to take the witness to that letter, but for your record, it is poll 001161112. There is then a further letter that is sent again for your record, poll 00297998. So I'm going to add to my list of things that happened in the summer of 2013, that by that stage you were also liaising with the CCRC on Post Office's behalf.
I wouldn't accept that characterisation of it. I drafted this one letter, which I think is a holding letter, sets out some very basic background information. Other than that, we were bringing in Brian Altman to advise on the CCRC approach.
Okay, so let's change liaising to corresponding with the CCRC. You were corresponding, or you were drafting correspondence to the CCRC.
I accept that I drafted this one letter.
That is correspondence, isn't it?
Yes.
Yes. Okay, and you were also, by that stage, liaising with criminal counsel. to take matters forward?
We were acting as a conduit so that Post Office could get advice from criminal counsel.
You were meeting with Brian Altman, discussing matters relating to the Criminal Cases Review Commission with Brian Altman, weren't you?
If we're talking July and August, I'm not sure if I ever actually met Brian in that period.
Okay, well, let's turn back to that email, the covering email, WBON 4037s. That's the bottom email. You say, please find draft holding letter. This just holds the current position until we have spoken to Brian Altman tomorrow. The suggestion being that there was going to be a meeting with Brian Altman the next day.
There was. I just can't recall whether I attended it or not.
Okay. So, July 2013, corresponding with CCRC and coordinating with Brian Altman, Casey?
I would say we were acting as a conduit for Brian's advice.
Who actually instructed Mr. Altman? Was it the Post Office legal team directly, or was it Bond Dickinson, or was it somebody else?
It was Bond Dickinson.
Right, thanks.
And in fact, if we turn to WBON 40393, bottom of the page, we see Mr. Altman on the 2nd of August, so shortly thereafter, sending Gavin Matthews, who was your supervising partner, and Simon Richardson, who I think ultimately became the chair of Bond Dickinson, Womble Bond Dickinson, is that correct?
Correct.
So two partners at Bond Dickinson. Mr. Altman is sending them his observations on the terms of reference and interim review of Cartwright King's current processes. So very clearly it was his view that they were the instructing solicitors. In fact, he doesn't even copy in the Post Office to that correspondence.
Bond Dickinson was Brian's instructing solicitors.
Yes. If we scroll up, we can see Simon Richardson sending that to you as well. He said, you ought to have this too. Scroll up to the top, please. Could we now please turn to poll 3021981? And those were the observations that were sent to you from Mr. Altman. If we scroll over the page, the inquiry has been through this, but I'll just highlight a few matters that are raised in those observations. Thank you. He sets out there, he understands the terms of reference are as follows. The first, to prepare by the 5th of August an interim review of Cartwright King's current processes. Second, to review and advise the Post Office in writing on a number of matters. The first is its strategy and process for reviewing past and current criminal prosecutions in light of Second Sight's interim report and or the role of Gareth Jenkins and his impact on any possible appeals. Second, its response to the Criminal Cases Review Commission. So that is the further letter, further to your holding letter. C, the identification of any flaws in the process of or from the evidence arising from the review of a statistically significant number of past prosecutions in which Horizon has been an issue in the proceedings. And then we have a third there, to review and, if appropriate, to recommend changes to the existing investigations and conduct of future prosecutions by the Post Office, including, if appropriate, the investigative prosecutorial role being undertaken by another authority. If we scroll down and over to page 3, please, we can see there is a footnote at the bottom of page 3. And he says as follows, footnote 4, it is for the Post Office and those instructing me to determine whether or not it is only the efficacy of i.e. effectiveness of past prosecutions, etc., that I am being asked to consider with the board, or in fact the potential safety of past convictions following Post Office prosecutions, i.e. whether, in my judgment, the Court of Appeal is likely to think that the conviction is unsafe, Section 2 of the Criminal Appeal Act. This is an important distinction. If it is the latter, then the appropriate term is safety of past convictions. I note in this regard paragraph 24 of Simon Clark's ESHAC, case review, etc. I don't need to read any more of that. But he says there it's for the Post Office and those instructing me to determine. So it seems as though Bond Dickinson weren't just providing a conduit, but it was certainly Brian Altman's understanding that Bond Dickinson at least had some input on the scope of that instruction. Would you accept that?
At this time, I was primarily focused on dealing with the response to Second Sight. This work was being conducted by Gavin Matthews and Simon Richardson, so I find it difficult to comment on exactly what the role was. My understanding was that we were a conduit for his advice.
Well, looking at this, does it seem as though, does it appear to you that in fact it was more than just a conduit?
It appears from those words that that's what Brian understood.
Could we please turn to poll 302190? An email from Gavin Matthews. So your colleagues here advising on the terms of reference. Dear all, please find attached 2 separate terms of reference for Brian Altman QC as amended in response to his observations document, which I also attach for ease of reference. Please note that the Post Office needs to decide on the issue of whether he is to be asked to report to the board on the efficacy or safety of past prosecutions. See note 4 on page 3 of Brian's observations. Simon and my view is that he shouldn't report on the safety of past convictions for 2 reasons. 1, this is likely to involve a more significant analysis and lots of cases, thereby delaying his report. 2, and potentially blurs the boundary between Brian Altman and Cartwright King's respective roles. The terms of reference need to be finalised in time for Brian's return from holiday. It looks from that email that your supervising partner was more than just a conduit for Brian Altman's instructions. He was in fact advising on the scope of Brian Altman's investigations, wasn't he?
It appears to a very limited extent there, yes. But I would note that Susan Crichton would have been well aware that Gavin and Simon were not criminal lawyers.
Technically correct, but they were involved in the instruction and directing the instruction and formulating the instruction of a criminal barrister.
They were, as I say, at this time I was working on a different work stream, so I don't have full visibility as to how they went about it, but I accept that my firm were the ones that instructed Brian. But my recollection, it's distant and dim now, is that the scope of the work was largely led by Brian and as instructed by Post Office.
A barrister is instructed to carry out work. Here we have a firm of solicitors who are instructing him, advising on whether a criminal QC looks into the safety of convictions. That's what's happening here, isn't it? A fair reading of this email. The instructing firm is advising on whether a criminal silk is looking into the safety of convictions or not.
I accept that email expresses a view on that question.
Is it that difficult to accept what I'm saying in that respect?
I think the context is really important, that we were instructing Brian largely because it made it administratively more easy for Post Office. And I don't think Post Office were expecting Gavin, Simon or I to give them any advice on criminal law because they knew we weren't criminal lawyers. And I think that context is really important. I think Susan would have probably Susan in the context here, would have read that as a practical view, but I don't think she would have been led by the advice she was getting from WBD on criminal matters.
But they're the instructing firm, and they are there, very senior partners. So Gavin Matthews, and you have Simon there, who, as we know, went on to become the chair. By that stage, 2013, was he a particularly senior partner within the firm?
I think he was the client relationship partner for Post Office.
Giving a view as to whether Mr. Altman should be reporting on the safety of past convictions.
I accept they were giving a view, but I think that the context of what we were doing is very important.
Could we please turn to poll 002988417? You're copied into this email that we've just been looking at. And now, if we scroll down, we're at the 20th of August 2013, and Roderick Williams is in fact now corresponding with Susan Crichton and yourself. So Gavin Matthews is not a recipient of this email. And Roderick Williams says as follows: I would like the terms of reference to include that Brian Altman QC consider and advise on how we satisfy the prosecutor's continuing duty of disclosure when issues with Horizon will continually be raised. So he asks a series of questions that he would like Brian Altman to be looking into. By way of example, we can look at the third bullet point. Is there anything we can do to limit the need to review all past prosecutions each time a disclosable issue arises? Certainly Roderick Williams, by the 20th of August, seemed to think that you were a contact point for advising on the terms of reference or assisting with amending the terms of reference.
My distant memory is Gavin might have been on leave for a few days.
So while your supervising partner was away, while you were working on issues relating to Second Sight, having been copied into previous correspondence about Brian Altman's terms of reference, you are now a sole point of contact relating to those terms of reference.
Simon Richardson's also copied on this email.
Yes, but you are in the to column.
I am. Roderick would have known me more than he knew Simon, which may explain why he addressed it to me and only copied Simon.
So can I add to my list of the summer of 2013 that by August 2013, you were involved with Brian Altman QC's terms of reference?
I think that overstates the position. My recollection is that I had very little involvement in the terms of reference, but I note that these documents were only sent to me a couple of days ago and I've not had an opportunity to go back and check the position.
It wasn't so long ago. Are you able to recall the summer of 2013 receiving an email relating to the terms of reference for Brian Altman? Is that likely something that you would have been receiving and something that you likely would have given an answer to?
I would have been copied in on various emails, but at this time, the work around Brian's terms of reference was being led by Gavin and Simon and not me.
Would you have read this email?
Yes, I suspect I would have read it.
Would you have been aware that the Post Office wanted to change the terms of reference to look at the prosecutor's continuing duty of disclosure?
I wasn't that close to the issues to have identified those points.
Do you think that your firm were competent enough to be dealing with issues relating to the prosecutor's duty of disclosure?
As I said, we were acting as a conduit, so I would have expected these types of issues to have been passed back to Brian for him to consider.
What does a conduit involve, though? I mean, is it simply a post box? Is it something more than that?
Largely, we were acting as a way of getting instructions up to Brian and answers back down again. On occasion, I can see that views will have been expressed on points, but I think, again, the context is really important. that Post Office were fully aware that Simon Gavin and I were not criminal lawyers.
And do you think it is right for your firm to be assisting in something that is outside of their competence?
It's outside of our core competence, but instructing counsel is something we understand, and of course we have the context to the whole situation being involved on the civil side.
So if your firm were involved in advising on whether Brian Altman's terms of reference should include the prosecutor's continuing duty of disclosure, do you think that's something that they could have advised on?
I don't. I can't speak for Simon and Gavin, but I wouldn't feel comfortable advising on that. I can see a view may have been offered, but ultimately I think all questions were deferred to Brian to consider.
What's the difference between a view of a lawyer and advice from a lawyer?
I think one of them is offering perhaps some pragmatic thoughts as opposed to definitive advice on the position.
And how would a client distinguish between pragmatic thoughts and actual legal advice?
By the nature of the way it's given.
What do you mean by that?
But if we go back to the last email, what you've got is an email that says something to the effect, I haven't got it in front of me now, that says these are Simon and Gavin's views and a couple of bullet points.
And do you think that nuance is understood by clients?
I think it would have been understood by Post Office, yes.
I said I'd come back to the insurance notification issue, and I'm going to turn to that now, but it's poll 000219991. Thank you. Now, it's that bottom email that I'd like you to look at, but you can ignore the date there because we're still actually in the summer of 2013 is the document that I want to take you to. You're forwarding this particular document to David Oliver and Chris Oyar on the 12th of March 2014. We can see there you're attaching a number of different documents. One is a settlement presentation, and we'll come to that settlement presentation. You say, this presentation is a talk I gave for what was at the time the Sparrow Steering Group. But it's the third one that I want to take you to now, Insurance Risks Note. This note had the dual purpose of advising the board, its contents were later reflected in a board paper, and acting as notification to the Post Office insurers, hence why this doesn't look like a traditional piece of legal advice. You refer there to the contents being reflected in a board paper. Did you see the board paper?
I've looked at that sentence again, and I think that sentence is wrong because I can't find any record of that paper going to the board.
Thank you. And it doesn't look like a traditional piece of legal advice. That's your words. Let's turn to it and have a look at it. It's poll 000219996. So why do you say in that covering email it doesn't look like a piece of legal advice?
Just because of the way it was drafted. This note was drafted to notify Post Office's insurers.
And how would legal advice act as notification to an insurer?
I don't think I'm suggesting that it was. What I'm trying to say here is this note was drafted for the purpose of notifying Post Office insurers of those issues that are set out in this note. I don't think it actually gives advice, say, on the merits of the position or what needs to happen next or things like that, which you would traditionally expect to see in a piece of legal advice. If you were the insurer and you saw Bond Dickinson on the top right-hand corner, you saw confidential and legally privileged, common interest privilege, litigation privilege, was it not designed to look like legal advice? I don't believe it was designed to look like legal advice.
What do you mean by common interest privilege there?
In the sense that if there was a claim against Post Office which was an insured claim, then there may be a common interest between Post Office and its insurers.
So the common interest there is between the Post Office and the insurer.
That's what that reference was from memory.
And was that designed to ensure that this document was not disclosable because it was covered by common interest privilege between Post Office and its insurer?
We considered that question, and on balance, I think we thought it probably was privileged communication of this nature to the insurers, but it could be challenged.
And was one of the reasons for adding common interest privilege at the top there to try and cover it in a blanket of privilege?
It was to indicate that we thought there was a common interest privilege might apply to this document.
It doesn't say might be common interest privilege.
I think it's just a heading to a document. It's designed to indicate to the reader that this document could attract common interest privilege.
Or is considered to attract common interest privilege. You wouldn't add it if you didn't think that there was a reasonable argument.
That's fair. At this point, my view is I thought this document would attract common interest privilege, but we thought that could also be challenged later.
Could we please scroll down this document? We saw earlier that email about concerns you had about notifying the insurer in writing that it could become disclosable. So the reason behind this being in the form that it is that that was an attempt to cloak it in privilege, thereby not disclosing it.
Whether or not the document is privileged depends on its nature and the purpose for which it was sent. I think lawyers, where they think a document is privileged, will often mark them as privileged, but marking a document as privileged doesn't make it privileged.
But you intended it to be covered by privilege. As in, this letter, if it's not advice, if it's not legal advice, it could have been written by the Post Office and sent to the insurer.
It could have been written by the Post Office.
It has been disguised here as Bond Dickinson advice, covered by legal privilege, with the intention that should somebody ask the insurer for a copy, or should the Post Office be asked for a copy, they could say it was legally privileged.
Would you mind scrolling back up to the top of the document, please? So the top of this document refers to common interest privilege and litigation privilege. It doesn't refer to legal advice privilege.
Yes. Common interest privilege. What's the point you're making? That because it doesn't say legal advice privilege, that means that it's not legal advice?
So I think your suggestion was that we were dressing it up as legal advice to try and get it under the banner of privilege. That wasn't what we were doing. This was drafted as a notification to the insurer. My understanding is when you notify insurers, and I got this understanding from one of the insurance partners, is the forms that are of privilege that might apply are litigation privilege and common interest privilege.
And it says at the top, confidential and legally privileged. Doesn't that cover all forms of legal privilege?
I think you're reading too much into those words.
Let's have a look at what it says. If we scroll down. Risks to Post Office, page 2, please. Prosecutions and convictions. As noted above, where circumstances warrant, Post Office prosecutes sub-postmasters who have acted criminally. The basis of these prosecutions is often found in the transaction records recorded in Horizon. As a result of Second Sight's investigation/interim report, Post Office is reviewing all its criminal prosecutions over the last 3 years to identify any cases where a conviction may be unsafe. In particular, the expert evidence of one of Post Office's witnesses, Dr. Gareth Jenkins of Fujitsu, may have failed to disclose certain historic problems in the Horizon system. Under the criminal prosecution guidelines, Post Office has an obligation to disclose, even retrospectively, this previously undisclosed information to sub-postmasters defence counsel. Post Office is required to make these retrospective disclosures where the additional information, i.e. Dr. Jenkins's knowledge of historic but now resolved problems with Horizon, may have undermined a prosecution case or assisted with the accused's defence. Reference there to prosecutions and convictions in cases relating to Gareth Jenkins, or where Gareth Jenkins has provided evidence. Could we please turn to poll 000400025? So that's the version that you sent colleagues, or Chris Oyard and who was David Oliver?
He was part of the mediation scheme team at Post Office.
So you sent that in March 2014 as the notification. But I want to look back now at the drafting process for that document. We have here an email from Roderick Williams to yourself, and he says, Andy, please find attached the Horizon Risks document, which I have amended following input from Cartwright King on the criminal law risks. Can you please check that it will still serve the purpose of notifying insurers of the grounds for potential claims? Once you're happy it does, I intend sending it to our broker under cover of the following email. Mark, Richard, please find attached a note from our solicitors outlining the risks presented by the recent investigation into Horizon IT system used in post office branches. So the proposed notification to the insurers is that it's a note from our solicitors outlining risks. I mean, that sounds quite a bit like legal advice, doesn't it?
I don't believe we considered it advice. I drafted it simply to set out the facts and backgrounds for the insurers.
Why couldn't you have drafted it on a piece of paper to be sent by the post office on their own headed paper?
We could have done.
Again, I'll go back to it. Surely the purpose was to add that level of privilege over it, wasn't it?
I'm not sure I gave it that level of thought as to whether it would come from Post Office or from Womble Bond Dickinson.
We saw that you gave it quite a lot of early thought about problems that it would cause if it were disclosed.
Yes.
So surely you thought about who should be sending it and why?
Not in terms of who... I don't believe I did in terms of who would write the note. I think it was just that we were in the position to write it. We wrote the note. And as it marked at the top, we considered it could be subject to common interest privilege and litigation privilege.
Can you please share this with our insurers so they are aware of the circumstances which could potentially give rise to claims against the policies that we have with them, preserving so far as possible the legal privilege attaching to the note? Doesn't the fact that it came from yourself strengthen that claim for legal privilege? And wasn't it intended to do so?
On the first of your points, I guess there is something in the fact that lawyers are considering legal risks that makes it more likely that litigation is in contemplation, which is one of the grounds you need for claim litigation privilege. I don't recall any discussion around whether the note should come directly from Post Office or from my firm in the context of making it more or less privileged.
I mean, it isn't really what's going on here that the notification to the insurers is being covered in LPP in order to prevent it from being disclosed.
I accept that we were asserting legal privilege over this document, yes.
For that purpose,
yes.
So that it wouldn't be disclosed.
Correct.
And in fact, although the draft email suggests that it's a note from our solicitors, we can see there that it is not only Bond Dickinson who are inputting, but Cartwright King and also Post Office themselves.
Correct.
So to suggest that it was simply a note from the solicitors, that wouldn't be right, would it? I mean, the impression given in that draft covering email is that this is something we've received from Bond Dickinson. Here you go. Here's a piece of legal advice we've received. But in truth, it was a document in which a number of different people had input into, which was put on your headed paper in order to cloak it with legal privilege.
As I say, it was drafted as a notification to the insurers to give them the factual information to assess whether there is insurance cover. I accept that we considered that communication to be privileged, but I don't and I accept that please find attached a note from our solicitors. I think that probably fairly describes what that document was.
Okay. Poll 30.
Sorry, Mr. Blake, before we go any further, it may be that I'm being a bit slow, but I just want to understand the drafting process. The document, which was, let me just ask the direct question. Who, so far as you're aware, Mr. Parsons, produced the very first draft of that document?
I created the first draft.
You did?
Yes.
Right. And that, so then the sequence was that you sent it to Mr. Roderick Williams, who amended it, as I've understood what's being said here, with the help of Cartwright King, in particular, so far as it related to the criminal law risks. Yeah?
That's my best recollection, yes.
Well, that's what this appears to say, this email,
Yes.
which is, I was checking it. So the part of the document which deals with Gareth Jenkins, this is what I was coming to, was that something which was in your original draft, or was that something which was added by Cartwright King stroke Mr. Roderick Williams?
So before Mr. Parsons answers that, could I take you to the attachment to this email, because that actually does address this issue, or it may assist Mr. Parsons.
Sorry, Mr. Blake. I appreciate that I was butting in, but I just wanted to get this sequence right in my mind.
Could we please look at the attachment? It's poll 000-40026. And perhaps when this comes up, could we also have it side by side with the version that you sent around in 2014? That's poll 000-21996. I can make very clear, the version that you sent around in 2014, in fact, was not the version that was sent to the insurers. Mm-hmm. And we're going to see the difference between them. So if we could turn to the second page of both of them, to the section on risks to the post office, please. Thank you. So they're very similar on the first paragraph, although there's the difference is that there's now reference, in the Cartwright King version that was sent to you, refers to 1st of January 2010 rather than over the last 3 years. So that's a change. And the more significant change is in that second paragraph. The version on the right-hand side says, Post Office has an obligation to consider whether further disclosure should be made to defendants. It is of concern to Post Office that the expert evidence of one prosecution witness, Dr. Gareth Jenkins of Fujitsu, may have failed to disclose certain problems in the Horizon system potentially relevant to a case. A case. The left-hand version says quite a lot more about Gareth Jenkins and is perhaps more accurate. It says, in particular, the expert evidence of one prosecution witness, Dr. Gareth Jenkins of Fujitsu, may have failed to disclose certain historic problems in the Horizon system. And it also says, Post Office is required to make these retrospective disclosures where additional information may have undermined a prosecution case or assisted with an accused defence. It doesn't refer there to a single case. The one on the right-hand side very clearly gives the impression that it's only one case that is affected. Do you recall that insertion?
Just to check, my version is the one on the left?
So, well, the 2014 version that you circulated is the one on the left.
Okay.
The one on the right-hand side is the one that was circulated by Roderick Williams with a covering email that said, please find attached the Horizon Risks document, which I've amended following input from Cartwright, King, etc. It's not at all clear whether the one on the left was the original version or some other version, but it certainly wasn't the version that went to the insurers. Do you recall in any way reference to Gareth Jenkins being amended?
I don't recall that change.
Do you recall that the final version that was agreed was a version that only said that Gareth Jenkins may have failed to disclose certain problems in the Horizon system potentially relevant to a case?
I don't recall that change.
Do you recall, in broad terms, discussing the changes, for example, in response to Roderick Williams's email, discussing with Roderick Williams the various changes that were being made to that document that had your header?
I don't recall discussing those changes with Roderick.
Let's look at the final notification. That's poll 00112856. So this is the notification from somebody called Stuart Corney, who was partner claims financial risks division. Dear Sir, Madam, please find attached details received of a new D&O matter for your consideration. The notice concerns challenges which have been made to the accounting system used in the post office network to monitor sub-post offices for any improper behaviour. And you'll see halfway down that paragraph it says, a review of the Horizon system was undertaken, and whilst recommendations were made for improvements, no systemic problems were revealed which would call into question the changes previously made against sub-postmasters. It is of concern to Post Office that the expert evidence of one prosecution witness, Dr. Gareth Jenkins of Fujitsu, may have failed to disclose certain problems in the Horizon system potentially relevant to a case. And if we scroll over the page, we can see the Bond Dickinson note, Horizon risks, that was sent. We scroll down. If we scroll over the page, we can see under prosecutions and convictions, the version is the version that only relates to Gareth Jenkins may have failed to disclose certain problems relevant to a case. So it certainly suggests that the version that was sent to the insurers was not that version that you sent round in 2014. And would you accept that that version is highly misleading?
Yes, it appears that way, though I'm not sure I was cognizant that that change had been made at that time.
Well, hang on a minute. This version, the one that on the face of it looks as if it was sent to the insurer, in respect of the heading prosecution and convictions, is identical, is it not, to the one which was sent to you by Mr. Roderick Williams, and the cover of an email which drew your attention to the fact that there'd been an amendment in relation to Gareth Jenkins.
I accept that a copy of it was sent to me. I don't now recall being cognizant of that change or its importance.
All right. That's your answer to that. And just to clear up where I started, the version that you sent around in March 2014, which wasn't the version sent to the insurer, was it the version, so far as you can remember, which you had originally drafted?
I believe so.
Right.
I believe so, but it did go through a few iterations.
That's your answer. You believe that your original draft contained the details which we see in what I'll call the 2014 document. But in fact, it was amended in 2013, and something different, namely what's on the screen, was sent to the insurers. Have I got that straight now?
That appears to be the case.
Fine, thank you.
Can we go back to the email from Roderick Williams? It's poll 3040025. So this is the email that he sent you with the version, as the chair has highlighted, is the version that was ultimately sent to the insurers. And if we scroll down, he has sent it to you and he says, please let me know if you have any comments on the proposed email or approach generally. Presumably you did correspond with him on this.
My distant memory is I think I responded briefly saying the cover note looks okay, or something to that effect.
Presumably you would have opened the attachment and read it.
I presume so, but I can't recall.
Looking at it now, is that paragraph not crying out for further detail?
It strikes me that now, but I don't remember considering that at the time.
Given the significance of the advice on Gareth Jenkins and the implications for criminal prosecutions, wasn't it important to get that absolutely right, that section?
This is a notification to the insurers, and so yes, it's important that it's accurate, but it's also at a high level of detail so the insurers are aware of the general issues that are in play.
Were you concerned when drafting this about the potential disclosability of the information that's provided and therefore seeking to minimise those problems?
I was concerned about the disclosability of the document, which is why we considered it to be a privileged document. In terms of its content, though, the version I produced was candid about the issues I felt.
Why in that 2014 email did you say that it had been summarised for the board? Where did you get that idea from?
So this insurance note was to the D&O insurers, the directors and officers insurers, and I think in the week or two before that I had provided Post Office with an email of advice on directors' duties, and looking back now I wonder if I got those 2 points confused.
Could we please turn to poll 001230004? Could we start on the bottom of page 4, please? We'll see that this eventually reaches you, but it's an email from Andy Holt to Martin Edwards. And the subject is information for Paula's one-to-one with the chairman. So it seems as though they are gathering information for a conversation between Paula Venables and the chair. If we scroll down, there is a section called Project Sparrow Update. So this looks like the original draft that was proposed for that one-to-one. And it sets out an update on Project Sparrow. The improvement work stream is completed. The as-is experience for sub-postmasters. The team are now progressing with the to-be picture and identifying the gaps and issues as well as the activities that will need to get us to our future model. There's a reference to the mediation scheme, now received 46 applications. Final stages of appointing Sir Anthony Hooper. Criminal case reviews continue with our external firm of solicitors. They've completed several sifts of past cases and have recommended disclosure on 11. Brian Altman QC's review is also progressing well and is expected to complete as planned by the end of October. If we scroll up, please, we can see on page 4 a response from Mr. Edwards to Mr. Holt. And he says as follows: thanks very much for this. A few questions/requests for further information. Would be good to include a line on the review of prosecution's policy, i.e. just updating the board that work is progressing and they will see a paper at the next ARC or board following yesterday's discussion. Please can we confirm the arrangements? 2, I think we should have a few lines on compensation policy. 3, I think the criminal cases review process needs more explanation. In particular, an explanation of the implications of the 11 cases where disclosure has been recommended, even if we don't want to include too much on this in the text itself, useful for Paula to have in her background notes. Can we also have an explanation of the high-level conclusions of the Brian Altman review along the lines outlined by Roderick yesterday? If we scroll up, we can see that Roderick responds saying, Andy, I've asked Andy P to respond to Martin's points. And then if we turn to the bottom of page 1, we can see that you have responded substantively to those points that have been made. So the bottom of page 1, please. We can see the questions there are slightly less bold than the answers. They, I think, in the original would have been in a different colour, perhaps. Draft answers to Martin's questions below, too much detail or not enough. So you are drafting, for Andy Holt, proposed answers to those questions. First one would be good to include a line on the prosecution's policy. You've drafted as follows. Brian Altman QC's review of the prosecution policy is being finalised. The report was originally due on the 31st of October, but should now be ready by the 25th of October. The review will address the question of how Post Office may wish to approach prosecutions in the future. Then you say, Andy, I'm not sure what the board process is for the report. Hugh mentioned there might be an extraordinary exco to review the report before it goes to the Audit and Risk Committee or the board. More answers. If we look at 3, where the request was, I think the criminal cases review process needs more explanation. You've put in there Jarnell, Cartwright King to amend/complete, but you have drafted a section on Brian Altman's first review, which you say has now been received. This first review looked into the Post Office's compliance with its prosecution duties in light of Second Sight's findings. In particular, it considered Post Office's legal duty to ensure that Second Sight's findings were fully disclosed to any person who is currently being or has previously been prosecuted by the Post Office. Mr. Altman concluded that the Post Office is complying with its duties and that the approach adopted by the prosecution team was fundamentally sound. This report gives the Post Office good grounds to resist any formal external review of its historic prosecutions, i.e. by the Criminal Cases Review Commission. Now, earlier this morning, you were very keen to emphasise that you were effectively a conduit for Brian Altman. It certainly seems from this email that you are, by this stage, so October 2013, substantively involved in advice on a brief that would go to the CEO of the Post Office.
This paragraph here is repeating the information I've had from Brian.
Yes. Were you involved in advising or drafting advice for the CEO that related to that underlying work?
I think this is just a factual summary of the status of Brian's report and reflects what I understood his advice to be.
Next question, further to yesterday's discussion, please could we also have some lines for background speaking notes on the process, etc. And then you say, Andy, Belinda, thoughts on the below. Work is continuing on managing Second Sight out of the scheme. In general, Second Sight's role is gradually being reduced until they can be removed entirely. You were involved at that stage by dealing with Second Sight. Was that the main part of your work then?
Correct.
You have, in this email, answered a request in relation to a briefing for the CEO, covering matters relating to the criminal cases review process, for example. No mention here of the Gareth Jenkins issue. Do you think that that's something that might warrant inclusion in an update to the CEO?
My understanding at this time is that everybody had been briefed on the Gareth Jenkins issue.
Was it not so significant that it perhaps required quite a significant update to the CEO.
Possibly, but that's also why the comment above says this needs to be run past Jarnail and Cartwright King.
In relation to Criminal Cases Review Commission, did you just see your job simply as repeating exactly what Brian Altman told you?
Largely because I'm not a criminal lawyer, so I'm not in a position really to amplify what he was saying.
Why instruct someone? Why be the instructing firm to somebody if all you can do is parrot what they tell you to the client?
So, again, the context here is that Post Office already have retained criminal solicitors in Cartwright King. The role of Brian Altman is to act as a second opinion on Cartwright King's work. Post Office wanted that to come from a QC. They weren't looking to instruct another firm of solicitors to do it. And so our role is to facilitate them getting that advice.
Did you feel comfortable in answering these kinds of questions from the Post Office?
In the sense that they were asking for a brief update of what had happened, I felt able to provide that.
Could we please turn to poll 003725551? This is the very same day as you're having this correspondence. If we scroll down slightly, we can see an email from Paula Vennells to Alice Perkins. So this is some form of one-to-one. Hi Alice, don't worry about the lateness of this note. So that's actually very first thing on that day. It's 12:47 a.m. I'm clearing I think it must be in tray before signing out. I hope your weekend has been good despite the autumn rains. It says a couple of updates, and updates on Sir Anthony Hooper /Sparrow. And then it says as follows: my concern re Sparrow currently is our obligations of disclosure re an unsafe witness. The representative from Fujitsu made statements about no bugs, which later could be seen to be undermined by the second site report. We do not think it is material, but it could be high profile. Martini is briefed if you want more detail. This is just in case. So it seems as though her belief at that point was that it was not material, or not thought to be material. If we could go back to the advice that we looked at much earlier today, please. And that's poll 00145-716. It's the middle email. This is the advice that I took you to much earlier today about notifying the insurer. And you said as follows: the risk of notification is that it would look bad for the Post Office if it ever became public knowledge that Post Office had notified its insurer. To reduce this risk, it is recommended that rather than sending formal written notification, POL speaks and verbally notifies them so as not to leave a paper trail. We also saw the advice that is attributed to you in that meeting, the first weekly Horizon meeting. Could that approach that you took to not putting things that are damaging in writing, to weakening of the Gareth Jenkins issue as we saw in that final notification, could that have been in some way responsible for the CEO's lack of understanding of the true gravity of the problem?
This is over a 3-month period where I'm not the one advising Post Office on criminal law risks, and I'm not the one who is responsible for ensuring what information goes to the CEO. As far as I was concerned, the CEO had been briefed on these issues.
Could the obsession with covering things, blanketing things in legal professional privilege have been responsible for that lack of understanding at board level?
Not as far as I was aware.
Could we please turn to poll 00022-002? This is the presentation that you sent again in that 2014 email that I referred to. It's dated the 8th of October of 2013. So, approximate period to that Paul of Ennell's email to Alice Perkins. You've said in that earlier email that this was a presentation that you gave to Sparrow, to the Sparrow Committee. Is that right?
Yes.
If we turn over the page, please. Your presentation says as follows: privilege, a reminder. Legal privilege is vital, equals vital to success. Do not discuss any legal advice or anything to do with sub-postmaster settlements with anyone outside the post office, JFSA, second sight, sub-postmasters, the sponsoring department, Department for Business and Industrial Strategy, members of Parliament, even your teams, unless absolutely necessary. Did you see legal advice covering things in privilege to be vital to the post office's success?
I think in the context of this document, which is discussing settlement criteria and what post office may and may not be prepared to pay, keeping that type of advice confidential is of paramount importance, and I think that the sort of advice that any lawyer would give to a client in those circumstances.
And looking back at it now, do you think that that was in some way responsible for a lack of information transferring within the company?
No, because this is talking about communications outside of post office and then potentially down into teams. I don't think anyone would have interpreted that as somehow putting a block on information being passed up to senior management.
It says your teams unless absolutely necessary.
Yes.
Don't discuss any legal advice, even with your own team.
Yes, because in this...
Keep information clearly compartmentalised is what it's advising, isn't it?
No, because this meeting of the steering group tended to be more senior people, and so the idea is that they will have more junior staff underneath them. And there's that's not just advice that I'm providing, that is the state of the law on legal advice privilege, which provides that legal advice privilege doesn't extend to the entire client organisation, but only those groups within the organisation who need to receive that advice.
Can we turn to page 14 of this document, please, still with the presentation? Settlement thresholds. You set out here recommended threshold of proof and risks, and where the nature of the complaint is that Horizon inaccurately records data/transactions. Risks. Post Office should be slow to concede that Horizon has any technical faults. To do so could open the floodgates to a large number of claims. It will be almost impossible to reverse this position if conceded. Now, all those things that we've been going over today, all those various bugs in the summer of 2013, suspense account bug, Castleton, Misra, all of those issues that we've been discussing, how, by that stage, could you still hold that position? Could that still fairly be the post office's approach?
So those three bugs that you just mentioned had all been publicly disclosed, so they were out there. So this is talking about us coming across any new defects in Horizon during the course of the scheme. Reflecting on this now, I think that sets the bar too high.
I'm going to address one more issue, sir, before we take our second morning break. I appreciate time is marching on, but perhaps we can take a slightly later lunch. Could we please turn to poll 000-29707? And page 3, please. In the middle of page 3, we have an email from Steve Darlington to Ron Warmington and the Post Office Group. And he says as follows: as Pretty has stated in her last sentence, we are seeking a stay on the time limits of all cases under review due to the implications of the Post Office's non-disclosure of system-generated transactions and horizon integrity issues. Do you remember who Steve Darlington was?
I think he was a lawyer acting for some of the applicants in the scheme.
Yes. So it's a complaint from Howe & Co. Following disclosure of, amongst other things, the Helen Rose report. He says, the Helen Rose report is of critical significance to all cases. The information contained within it is a compelling case for such a stay in its own right. When combining with the Andy Wynne/Alan Lusher email in the case of Ward, which explicitly states that Fujitsu can remotely change the figures in the branches without the sub-postmaster's knowledge or authority, the case for a general stay is overwhelming. We ask that the working party considers this request as a matter of urgency in order that we do not prejudice our clients' cases by omitting what is clearly information of the utmost general significance. If we please scroll to the first page, please. You provide your view on this email. You say as follows: Belinda, I've spoken to both Roderick and Simon Clark at Cartwright King about the email from Pretty Singh at Howe. So Pretty Singh is the lawyer at Howe who's made this complaint. And all three of us have similar thoughts on the way to proceed. The only redactions made to the copies of the report sent to sub-postmasters was to remove, 1, the personal information of some of the individuals named in the report, 2, a header in the document that said the document was subject to legal privilege when it clearly was not. In light of this, I don't understand Howe & Co.'s complaint that there is substantial missing material. It is not suggested that the Post Office provides an unredacted version of the report, as 1, this is not necessary, and 2, we do owe some duty of privacy to the individuals involved. Instead, it's recommended that the Post Office maintains its current position and simply explains the redactions to the report. So this is the Helen Rose report that has been redacted. You are here explaining why there have been redactions that have been made to that report. Is that correct?
Yes, the redactions were made by Cartwright King, though, not me.
Yes, and you are explaining why they have been made.
I'm explaining why Cartwright King's reasons for why they were made.
And you are suggesting an approach that the Post Office should take in response to Howe & Co.'s complaint about the redactions.
Yes.
And that document had been disclosed to the individual in the criminal context. It had been part of that criminal disclosure arising from Cartwright King's review.
I believe that's the case.
Yes. You say, in this vein, I've set out below a possible response to Howe & Co. to go from Chris. This response is purposefully short in order to avoid any dialogue with Howe on this matter. I do not believe this matter need to go through the working group, as this is about the Post Office's prosecution duties and not scheme business. The response could, and in my view, should be sent regardless of Steve Darlington's email below, as it is important that the Post Office's position is clearly stated before Ron begins to escalate Steve's views to the working group. Now, I do not believe this matter need to go through the working group, as this is about Pol's prosecution duties and not scheme business. You've been very clear throughout this morning to distinguish between your involvement in civil and criminal matters. It is clear here that you are getting involved in correspondence that relates to the Post Office's prosecution duties.
So this is where we end up with the overlap between the scheme and the fact that within the scheme there were some sub-postmasters who were convicted. My lookout from here is to determine whether this is a matter for the scheme to consider or not, and the scheme was not considering Post Office's prosecution duties or reconsidering the conduct of prosecutions. So I don't accept that is me advising on prosecution matters. I think that is me advising from the perspective of the scheme.
You're advising on something that touches on prosecution's duty of disclosure, aren't you?
I accept that, but also if you scroll up to the top of this note, it says I've spoken to both Roderick and Simon Clark at Cartwright King. So the criminal law input would have come from Simon Clark at Cartwright King.
But he's not sending any separate draft response. This draft is coming from you. having taken others' views.
Having taken Simon Clark's views on the appropriate approach on the criminal side.
And you say, just for background information, the material part of the Helen Rose report has nothing to do with her comments about reversal data. Second Sight and Howe are taking this point as evidence of a problem with the integrity of Horizon. In fact, Helen's issue was that the credence data, although accurate, did not on its face clearly distinguish between automated reversals and user-generated reversals. This information is available, but in a different report. The concern was not with the data's accuracy, but the presentation of the data could be misleading if its limitation was not fully understood. Putting this issue aside, and this is the important part, the real and confidential reason that the report was disclosed was because Helen's comment at the bottom of page 3 suggests it was widely known that there were problems with Horizon. This statement, regardless of whether it is correct, could have been used to attack Gareth Jenkins's credibility as the Post Office's Horizon expert, as he had previously stated that there were no problems with Horizon. And then you go on to draft the response. If we scroll down, please, your draft response says as follows. The version of the report sent to Ms. Robinson was redacted to protect the privacy and personal information of the individuals named in the report. This was done to ensure compliance with the Data Protection Act. All material information in the report has been provided to your client in full compliance with the Post Office's legal duties. Now, where you say legal duties, do you mean in relation to the prosecutor's duty of disclosure?
Yes.
So you are, in this draft email, proposing correspondence that relates to the prosecutor's duty of disclosure.
Having taken that from Simon Clark at Cartwright King.
We will therefore not be providing an unredacted copy of the report. So that's a decision that you also came to, or advice to the client that was encompassing others, but ultimately also your advice.
That was my advice, having discussed it with the criminal lawyers.
For the sake of good order, I note that the Post Office disagrees with the statements in your email about the integrity of data on Horizon and the safety of conviction. I don't believe that this matter should delay the submission of your client's CQRs. I want to look at the version of the Helen Rose report that was attached to Ms. Maru Singh's email that was being brought to your attention. And I want to look at it side by side with the unredacted version of the Helen Rose report. So could we bring up on screen poll 30022598 side by side with poll 0014749. So that is the original version of the Helen Rose report. And this is the version that's about to come up on screen is the version that was sent as part of that complaint from Howe & Co. And this is the redacted version. And you've explained the redactions in your witness statement. I think it's paragraph 182 of your witness statement. We don't need to turn that up. If we could, so the author's name is redacted, Helen Rose, but if we turn over, please, to page 2 on both of them. We see there the first redaction is to the branch details. Second redaction is a username. But let's look at that third redaction, please. The sentence on the right-hand side, the real version, if we scroll down, sorry, thank you, it says the Fujitsu logs were requested for this branch, but whilst waiting for these to arrive, communications took place with Gareth Jenkins at Fujitsu for more details to gain an understanding what had occurred at this branch. We then have the redacted version, which you say is for data protection reasons, to the name of Gareth Jenkins. We then have a look at question 1 and the redactions that are made there. On the right-hand side, the original, I am requesting Fujitsu logs for the Lepton branch to look at reversal, etc. And then we have in brackets, Gareth looked at the data at his end prior to me receiving the Fujitsu logs, And we see there the name Gareth is redacted. Now, how on earth could sub-postmasters have attacked Gareth Jenkins' credibility, as you've suggested was the purpose for disclosing this, if Gareth Jenkins' name was redacted in that report?
I'm not suggesting that. This was redacted by Cartwright King. I had no involvement in selecting those redactions or the reasons for those redactions. You would have to address those questions to Cartwright King.
Well, let's look at your email, poll 000297007. I think you practice in data protection, don't you?
I do now.
Let's have a look at the covering email. Poll 30297007. You make clear in that email, the only redactions made to the copies were sent to remove the personal information, etc. We scroll down, we can see your draft covering letter to the complainant from Howe & Co. If we scroll down to the bottom, the version of the report sent to Ms. Robinson was redacted to protect the privacy and personal information of the individuals named in the report. This was done to ensure compliance with the Data Protection Act. I mean, did you not apply your mind in any way to the redactions that had been made to that report when drafting this email?
So the redactions were made by Cartwright King. They told me they made them for data protection reasons. Having looked at the report, it appeared to me that they were redacting personal data, subject to that one extra point around the mismarking of the document as privileged. That's how I took their view on it.
You've said here, sticking with this email, putting this issue aside, the real and confidential, so nobody's being told, the real reason the report was disclosed was because Helen's comment at the bottom of page 3 suggests that it was widely known that there were problems with Horizon. This statement could have been used to attack Gareth Jenkins' credibility. Gareth Jenkins' name was redacted from that particular version.
Again, you're going to have to take that up with Cartwright King. I wasn't involved in the disclosure of this document or the redactions.
Why are you repeatedly drafting emails, sending substantive comments to the post office when you weren't involved, where you were just a conduit for information? Why were you doing that? Why were you not thinking through the consequences of the things that you were advising?
So this is where we get to the crossover between the scheme and the fact that some applicants in the scheme were convicted. When those crossover issues came up, as you can see here, I went and spoke to the criminal lawyers. I feel like this email faithfully represents the advice they gave to me, and I'm passing that advice back to post office.
I've noted down all those things that happened in the summer of 2013. So we've got suspense account bug that was brought to your attention, concerns regarding the integrity of Horizon. You had raised concerns regarding the documenting of certain information. Castleton, Misra, other cases on hold. Second Sight report, 3 bugs. You corresponded with the Criminal Cases Review Commission, however you would like to put that. You are here in 2014 directly involved in advising the Post Office in respect of a document that was disclosed following a criminal conviction and saying that we don't need to unredact the redaction to Gareth Jenkins' name. Aren't you?
Following the advice of the criminal lawyers.
Why in those circumstances wouldn't you have given it a little more thought?
I wasn't advising on the prosecution disclosures. I'm a civil lawyer. I don't have any experience of criminal law. When these types of issues came up, I took the lead from the criminal lawyers, particularly from Simon Clark, who's much more senior than I was.
You were asked to unredact the Helen Rose report. Your advice to the client is you don't need to unredact the Helen Rose report. Those redactions were made for data protection purposes. why wouldn't you satisfy yourself that they were sufficient, that they were correct, that they were fair?
So I have no independent means of doing that because I'm not a criminal lawyer. So I can't advise the client independently on whether those redactions were appropriate or not. The best I can do is go and speak to the criminal lawyer who made those redactions and seek his view.
You knew the significance of the Gareth Jenkins issue. You had read Cartwright King's advice. You knew that the disclosure was being confidentially made for the purpose of disclosure. Do you think, looking back at all of that, you really reflected enough on the job that you were doing?
I think reflecting back on it now, I think there was probably an original mistake by the criminal lawyers in redacting Gareth Jenkins' name and not being more transparent about his involvement and why they were making the disclosures back at the beginning of 2013.
Why is it all the criminal lawyers' fault? You were here involved in matters touching on criminal law, weren't you?
I hope I've tried to explain my involvement with the criminal touch points, but as I've said, I'm not a criminal lawyer. I don't know these rules and I couldn't advise on them. What I'm trying to do here is helpfully give Post Office the advice they need, acting, as I say, and I know you don't like this phrase, but as a conduit for the information from the criminal lawyers.
Should there have been a point where you said, I'm sorry, but I can't act as a conduit anymore. This is so outside my area of expertise that I really can't assist you?
I didn't feel it at this point on this particular issue, no. Having spoke to Simon Clark, he was clear to me that he thought those redactions were properly made.
So that might be an appropriate moment. I appreciate it's late in the day, but if we could only take our second break of the morning, so to 12:40.
Yeah. And then how?
And then we can take lunch at 1:30, if
So
that's suitable.
lunch at 1:30. All right, fine.
Thank you, sir. Thank you, sir. Can we please turn to poll 00146-243? And it's page 4 I'd like to look at first, please. Bottom of page 4. We're now on the 2nd of September 2013. We have an email from Alwyn Lyons, the company secretary, to Hugh Flemington, and she says, as per our conversation this morning, I would appreciate if you would get external advice on any risks in the lessons learnt review work. My concerns are specifically around the Freedom of Information Act or disclosure requirements for our criminal prosecutions and civil actions. If we scroll up, Hugh Flemington sends it to you. As discussed, I've been asked for the advice per email below. Would you mind reverting to me in the first instance? And we have the response, and that begins at the bottom of page 2, please. Your response is as follows. Simon, as discussed, please find below the high-level advice on the terms of reference for the lessons learned review. In general, the Post Office's desire to review past activity and improve the future is understandable. However, the nature and timing of the review presents several risks to the Post Office and critically cuts across a number of ongoing activities. For these reasons, I would recommend that if the review does need to take place at all, then it should be deferred 6 to 12 months, so to first allow Second Sight to be managed out and the mediation scheme to be completed. And then heading disclosure of the review. Privilege. This review will not be legally privileged. This may make it difficult, if not impossible, to resist publicly disclosing details of the review, as well as any documents and emails produced in the course of preparing the review. In a Freedom of Information Act request is made by, say, the media, JFSA, or a sub-postmaster. Still under 1, the second heading under 1, criminal disclosure. Should the review reveal any concerns about Horizon or branch accounting processes, then Post Office may be obliged, under criminal procedure rules, to proactively pass this information to sub-postmasters involved in criminal prosecutions, both ongoing and historic. In particular, recommendations for change could be interpreted as highlighting historic problems that would need to be disclosed. Everything we've been talking about this morning, you've been very concerned to distinguish between your role as advising in relation to the civil matters only, not criminal matters. What do you have to say about a paragraph here where you are advising on criminal disclosure?
So this is a very basic statement of the disclosure duties that Post Office was under, and I've taken that from the advice that I've seen previous to this from Cartwright King.
Are you advising the client in this email of the implications of the lessons learned review in respect of criminal disclosure obligations?
Yes.
Thank you. Can we please now turn to poll 0021865? We'll come back to the 2013 period, but I want to take you now to a few events over subsequent years that may be relevant to what occurred in 2013 and advice that you gave. This relates to the Panorama broadcast, and you are providing Roderick Williams with your thoughts on the confidentiality position following Panorama. And you say as follows: my thoughts are on below. In short, my view is that the Post Office either, 1, does nothing but a bare denial of the allegations and waits for the Criminal Cases Review Commission, or 2, goes on a full attack, with the former being my strong preference. Any middle ground simply feeds the fire, and I don't believe that steady reasoned argument or disclosure or further documents will assist in changing the story. Then there's a section on applicants. And you say as follows: I'm not convinced that responding to the inappropriate theft charge allegation for each case with a more detailed explanation of what happened would be worthwhile. Our arguments are technical, rely on the intricacies of the prosecution process, and are based on a range of putting evidence rather than a single smoking gun, and a range of evidence rather than a single smoking gun. The man in the street will simply say, where is the evidence of the sub-postmaster putting the money in her pocket? I don't believe we can win this battle in the media. You have there a fair grasp in broad terms of the criminal arguments, don't you? The criminal law arguments.
At a very high level.
You then say the post office could, however, start attacking the postmaster's credibility by calling out Thomas, Misra and Hamilton. Those are three people who've been convicted of criminal offences as the liars and criminals that they are. Now, how could you say that, having, for example, by this stage, received the advice on the reliability of Gareth Jenkins?
Yeah, on reflection, that language is too strong.
They all admitted to false accounting and all admitted to it again last night on Panorama. The Post Office's language to date has been constrained. Last night it was deliberate dishonest conduct, which was a gentle way to put it. Perhaps some more punchy language, combining with more specific details of the false accounting, might help rebalance public perception. Do you think that that was appropriate advice to be giving?
I don't think that's the advice I'm giving. If you read the opening paragraph that you touched on, it makes it very clear that my advice is that Post Office should do nothing and wait for the CCRC. What I'm then setting out below is the alternative proposition, but that wasn't the advice I was giving them.
The advice you're giving is that there are two options. The former is your strong preference, but you haven't ruled out the latter, have you?
No, I'm giving the client options and then giving them what my preference would be, which would be to do nothing and wait for the CCRC.
And do you think that that second option was appropriate?
I think it was an option that Post Office could consider, but as the top paragraph says, it wasn't what I would recommend they do.
And how is it advice relating to a legal position rather than effectively PR advice responding to the Panorama programme?
Apologies, could you put the question again?
Absolutely. You're looking there, an option, although admittedly one that wasn't your strong preference, was to attack the postmaster's credibility by attacking Thomas, Misra and Hamilton. How is that legal advice rather than, for example, PR advice because it's responding to the Panorama programme?
I think the Panorama programme, and I haven't watched it since that time, it was a long time ago, did stray into questions around legal responsibilities and liabilities. So I accept there's a grey area here between legal advice and PR advice.
If we scroll down, there's also comments there on Second Sight. And you say, for the reasons given above, I don't believe that a substantive debate over Second Sight's views on the inappropriate theft charge allegation would be successful. Whatever we think about them, the wider perception is that they are independent experts and credible. Just pausing there, by 2015, what did you think of them?
By this point, I had concerns about the quality of the work they were producing.
Just the quality of the work?
I also had concerns about that they seemed to be leaning more towards the sub-postmasters and ignoring some of the points the Post Office was making.
You then say, if the Post Office wished to respond, I would again recommend attacking their credibility and start with disclosing the extract from their engagement terms that says it is acknowledged that matters relating to criminal law and procedure are outside Second Sight's scope of expertise. Now, you've identified a couple of issues that you had with the quality of Second Sight's work, but how could you attack their credibility?
In this sense, it was because Second Sight had accepted in their engagement terms, again I'm doing this from memory, that they didn't have expertise in criminal law and procedure, yet they had gone on to offer opinions on those matters.
Looking back at this email, Is it your view that the advice that you were giving there and that the language that you were using about sub-postmasters was not appropriate?
I accept that the comments about the 3 sub-postmasters and name was inappropriate, but I think it all has to be read in the context of the top part of the email where it says my strong preference is Post Office does nothing and waits for the CCRC.
And reference to the CCRC there, reference to the inappropriate theft charge, referring to the credibility of 3 criminal defendants, it seems once again to be straying somewhat into the criminal sphere, doesn't it?
As I've explained, there are touch points between the criminal areas and the mediation scheme and the civil areas. Those points come into contact with each other, but I don't believe that I'm crossing the line into advising on criminal law matters here. To the extent that I refer to criminal matters, it's based on advice I've received from the criminal lawyers.
Bare denial of the allegations and waits for the CCRC, though, that comes pretty close, doesn't it, to advising in relation to how the company acts in respect of the Criminal Cases Review Commission?
I think that the status quo at that point is Post Office was waiting for the CCRC, so I don't think that's telling Post Office anything new.
And as I said, I'm going to go over jump a number of years now, to a few different periods. Let's move on a year and go to WBON 40465, please. And this is the 5th of October 2016. Amy Prime emails you. Who was Amy Prime?
She was a solicitor in my team.
She was, by that stage, a newly qualified solicitor, wasn't she?
Correct.
I think we've seen her involvement in some other stages, perhaps when she was just a trainee. But by this stage, she's qualified that year?
I believe so.
She says, Andy, please find below a draft email to Rod on the investigations guideline. Would appreciate your thoughts/comments on this. And then she has below a draft that has been drafted. Roderick, the below is not urgent, but for you to consider as and when you get a chance. Freeths have requested that we provide them with Post Office's investigation guidelines since 1998, including any revisions to date. In the earlier round of disclosure, we did not provide the guidelines since we wished to confirm whether the documents were covered by privilege. Brian Altman has confirmed that they will not be covered by privilege, and as such, the guidelines will at some point have to be disclosed. We have reviewed both the most recent version of the guidelines and the prior version. Of note, the 2013 version provides, should the recent second site review be brought up by a subject or his representative during a PACE interview, the security manager should state, I will listen to any personal concerns or issues that you may have had with the Horizon system during the course of this interview. Freeths will more than likely use this statement as an opportunity to confirm that Post Office responded to postmasters using stock answers, a point which has already been raised in relation to the helpline, and further could be spun to show that Post Office was not taking issues with Horizon seriously and were trying to ignore any issues which were raised. Although we may face some criticism later on, we are proposing to try and suppress the guidelines for as long as possible on the grounds that the most recent version is not relevant since it postdates the investigations complained of, and it would require a full disclosure exercise to piece together all historic revisions of the guidelines. We thought it would be best to bring this to your attention early. You respond to Ms. Prime the same day. Let's have a look at WBON 40464, please. Sorry, 467. Thank you. You respond as follows. One addition below, little tip, try to always spell out exactly what is required from the client, even if that is nothing or a negative statement like below. So you're there providing a tip to the newly qualified solicitor. Were you her supervisor or were you...
I'm not sure if I was formally her supervisor, but she was a lawyer in my team.
Okay. And you're providing her with a tip to spell out exactly what is required from the client. And if we scroll down, we can see on the second page the paragraph that you have then inserted. That reads as follows: "For now, we'll do what we can to avoid disclosure of these guidelines and try to do so in a way that looks legitimate. However, we are ultimately withholding a key document, and this may attract some criticism from Freeths. If you disagree with this approach, do let me know. Otherwise, we'll adopt this approach until such time as we sense the criticism is becoming serious." Now, you've addressed this in your witness statement. If we could perhaps keep that on screen, but also just bring up on the witness statement onto screen, page 235. So it's thank you very much. It's page 235. So the explanation starts at paragraph 411. 412, you come to this particular document, and let's see, the explanation is at 413, so that's over the page, please. You say, "Regrettably, this email is worded very poorly. Whilst, as I have said, I do not recall this email, my firm's records show that Amy had sent a draft for my approval earlier that day, which did not contain this final paragraph. I responded to her, adding it into her draft, though my purpose in doing so appears to have simply been to make clear what action we required from the Post Office on this point, rather than to consider or build upon the substance of her email. Though ill-expressed, having reviewed the relevant emails from around the time, I consider that that document and the final paragraph in particular does not reflect the true position, as there were in fact substantive legitimate reasons for resisting disclosure of the investigation guidelines at this early stage. My email should have been better expressed to make that clear at the time." I mean, let's take that down on the left-hand side and let's concentrate on that paragraph. It's not just a poor choice of words, is it? I mean, even if you take out the word in terms of legitimacy, so let's take out "that looks legitimate." What you are saying here is that we are ultimately withholding a key document. I mean, that's not a poor choice of words. That is your acknowledgement at that time that there is a key document, that it is okay to withhold that document for as long as possible, isn't it?
So we are advising Post Office here not to disclose this category of documents. I think the reference there to a key document is not referring to those two specific versions we have, but the broader category of investigation guidelines, which is what the request was.
So the investigation guidelines, that is the guidelines that led to people's investigation, subsequent prosecution, conviction.
No, the request was for investigation guidelines in the broadest sense, so it could have included any form of investigation inside Post.
Okay, so not limited to criminal prosecutions, but including investigations that led to criminal prosecutions.
Correct.
Including investigations that led to people wrongly losing their jobs.
Yes, I guess so, but I wouldn't be able to draw that line directly.
Investigations that led to people becoming bankrupt.
Yes.
And irrespective of your reference to doing so in a way that looks legitimate, you are saying there, you are advising a client that you can withhold what you considered at the time to be a key document until the criticism is such that it's becoming serious.
So the context here is this is in the pre-action phase of the litigation. No disclosure orders have yet been made. And the request that was made of us was for a broad category of investigation guidelines. The two documents we had were dated from August 13 and 2016, and therefore post-dated, in this sense, any prosecution that Post Office had conducted. Because as I understood it, Post Office hadn't conducted any prosecutions after after July 13. So in that sense, I thought they're looking at it now. It's a very poorly worded email. I regret sending it. But having looked at it again, I believe there were legitimate grounds to not disclose those two documents at that point in time, which is during pre-action.
What does it matter? What does it matter what you think now about those documents? At the time that this document, this email is drafted, this letter is drafted, you considered that it was a key document, didn't you?
I considered the investigation guidelines as a category a key document, yes.
And your advice to the client was withhold until criticism is so serious that you have to disclose, isn't it?
Withhold those two versions of the document, which is the only two versions we had been provided at that time. They're the only two documents we'd been provided with under that broad category of investigation guidelines. For the reasons that are stated in this email, we considered they weren't disclosable. That's not retrospectively my position. That was my position at the time. You said earlier the explanation for this began at paragraph 411. I think it begins at paragraph 404, and it does set out the background.
But what does it matter now that you consider those documents were not disclosable, if at the time you thought not only are they disclosable, they are the key document?
No, apologies. Maybe I'm not being clear. The email is poorly expressed, but my belief at the time was that those documents were not disclosable.
Your belief at that time was they were not disclosable?
Correct.
Where on earth in this correspondence does it say that? How could anybody reading this get the impression that your view was that they were not disclosable? How does that paragraph, how could that possibly be read as suggesting that it wasn't disclosable?
So the explanation is in the paragraph above, where it says the most recent version is not relevant since it postdates the investigations complained of, and it would require a full disclosure exercise to piece together all the historic versions of the guidelines. Again, the context is important. This is during the pre-action phase of the litigation, where a party is not required to undertake a disclosure exercise.
I mean, doesn't this show a mindset that we have already seen from 2013? Not to record, not to disclose, or if you're going to have to disclose something, hold on to it to the very last moment until you absolutely have to disclose it.
I think each of those has to be considered on its own merits and its own circumstances at the time. I think against that I would weigh the fact that we advised Post Office to run the mediation scheme, which is itself is a process that gave rise to lots of information being provided to sub-postmasters. So I think there are other points on the other side of that equation.
Let's look at the same criticism but in different circumstances. We're going to look at the known error log. Can we please turn to poll 002453938, please? Okay, if we could turn to page 5. There's a request that is sent to the Post Office. I think it's by Tim McCormack, although slightly facetiously it's entitled A.N. Nobody or A Nobody. And if we it's page 5, the bottom of page 5. He sends an email to the Post Office and he says as follows: I thought I sent a reply to you, but it doesn't seem to have got through. I cannot talk to anybody about this because I've signed off my branch accounts with the wrong figure, and I can go to prison for doing that. I haven't taken any money. I want to know what errors to look for. I read all this talk about errors in Horizon on the internet. I want to know what they are. You say you have that information but won't give me it, so what is my alternative? I don't have the sort of money to give to you. Will you prosecute me for my accounts if I talk to Mrs. Bogard? Please tell me, surely you have to tell me what these errors are. So what he's doing there, what that email is designed to do, is to try and draw out of the Post Office information about known errors. Because if you were a sub-postmaster who had signed off your branch accounts. You know there's a problem, but you don't know what the problem is. You want information from the post office to tell you what are the problems, what are the known errors that might explain my discrepancy. Did you understand that to be the background or the picture to be painted here?
I can see those are the questions being asked, but the fact that it was sent from a NO body made me doubt the veracity of this request.
Absolutely. So it may not be somebody who's actually having a problem, but it poses a theoretical problem for the post office to answer. Let's go to page 1, and this is your advice on that email. You respond to Roderick Williams, you say, draft business as usual response attached. I've gone for a very soft tone, although I'm 99% sure this is a fictional case, we just can't take the risk. I've not made any express reference to the known error log. Even the phrase known error could set hares racing, so I've avoided it entirely. I hope, however, the key message, cart before horse, still comes across. Were you concerned, even at 2016, about disclosing the fact that there was a known error log?
So at this point in November 2016, the group litigation is underway. Briefs are aware that there is a known error log. There's ongoing discussions around the disclosure of a known error log. So the fact that it exists is out there with the claimant's lawyers. I think the response here is in the context of this feeling like a fictional request, or an improper request for some improper purpose. And I don't think post offices should be required to provide extensive details in those circumstances where it feels like the request is somehow being made as a try on or a joke.
What did you mean by set hares racing there?
Because I think the phrase known error I think conjures up views in people's minds around the extent of problems. And at this point in time, we had been told by Fujitsu that the known error log didn't contain any bugs that affected didn't affect branch accounting.
Let's fast forward to 2019. Could we please look at poll 000431147? We're now in the thick of it in the litigation, addressing the known error log. An email from you to Roderick Williams and others. Rod, Kate, bullets for comment. Below is a possible email to Ben. I think that's Ben Fote, is it?
Correct.
To Rod. Attached is an updated board report. And then the email says as follows: Ben, please find attached the updated board report addressing your points. The key points to note are: 1. Womble Bond Dickinson are assessing the risk over the weekend of the 93 high-risk known error logs. By, and then a date next week, Council will have reviewed those in detail and given a view on whether they are likely to cause the Horizon trial to be recommenced / the judgment delayed. 2. In relation to the circa 14,000 other known error logs, i.e. those not used at the trial, the key risk of reviewing the 14,000 is that the claimants have not asked for the documents yet. If we review them now, Post Office will be required to disclose any adverse documents uncovered. This is doing the claimants' work for them and may highlight new bugs in Horizon that the claimants have previously decided not to raise or overlooked. The advice of Womble Bond Dickinson, therefore, is that the Post Office should not review the 14,000 other known error logs unless the claimants ask for them or Tony's review highlights major risks that warrant a wider review. So your advice there is that you shouldn't look at that wider body of error logs because there may be bugs in there that are found that need to be disclosed.
No, not quite, because these 14,000 CELs are back versions of CELs. So the final version has been disclosed already within the group litigation. So these are only earlier versions of documents that have already been put out there. And so they may contain more information about already disclosed problems, but I think it's unlikely they would have contained existence of new bugs.
This is doing the claimant's work for them and may highlight new bugs in Horizon that the claimants have previously decided not to raise or overlooked.
Yes. There is a possibility of that, I accept that, but I think the context is important that these are back versions of KELs that have already been disclosed.
Once again, is this a concern in relation to looking things for things or mentioning things just in case they had to be disclosed?
Well, at this point, we've already informed the claimants that there are these 14,000 KELs, and they can, of course, request them and disclose them, request them and review them if they wanted to. In a piece of litigation like this, I don't think it was incumbent on Post Office to have to review those documents.
Were you concerned that if you carry out too many investigations at this stage, there would arise some information about the integrity of Horizon that would be disclosable that you wouldn't want to be disclosed?
I think the depth of information around Horizon was massive. There were hundreds of thousands of documents, and I think if you review more technical documents on the system, there was always a possibility that it would give rise to a new problem. That's just an inherent risk in a pile of documents that big, and if that happened, we would have to disclose it.
And that's looking about in the system, but what about discussing things with Fujitsu, for example? Were you concerned about discussing things with Fujitsu just in case they gave you something that you might have to disclose?
I don't recall that being a consideration in terms of us being worried that Fujitsu would tell us that there was something to be disclosed. In fact, we repeatedly asked them for that type of information.
So you were repeatedly asking Fujitsu for information, and what is your concern that they weren't giving it to you?
For example, if you go back, and this is 2019, if you go back to the earlier stages of the KEL, when we asked them about the KEL originally, and we asked them explicitly, are there any bugs that affect branch accounts within the KEL, they told us there weren't any.
Let's look at POL 000-43169, please. We're still on the KEL. Bottom of page 1, please. An email from you to Catherine Emanuel, Roderick Williams and others. No more progress on the known error log review because I've asked Tony to turn his efforts to the known error log response letter that now urgently needs to go out the door. He'll then circle back to the remaining KELs to be reviewed, of which there are about 15. We will then have a short list of about 25, I'm guessing, KELs that will need Fujitsu's input. We are collating a list of all questions to Fujitsu on these 25, but before sending that to Fujitsu, we need to take a tactical decision on whether that is a good idea, bearing in mind that sometimes we ask Fujitsu a question and get answers we don't like. And isn't that the opposite of what you've just told me in respect of your relationship with Fujitsu?
I wasn't concerned there that they would turn around and say, look, there's some more bugs in the system. If they'd have told us that, we'd have disclosed it. The challenge at this stage was that the answers we'd get from Fujitsu would be opaque or difficult to understand and could lead to lines and lines of questions, which means what we were trying to do here is move this matter to a conclusion.
Surely what you're doing there is very similar to what we saw from 2013 onwards, which is don't seek something out, don't get hold of a document or information because you might have to disclose that and it might be something that we don't like.
I don't see the dots that you're connecting there, I'm afraid. As I say, you have to consider each of these points in time as you look at them.
So that might be an appropriate moment to take our lunch, please.
Certainly.
Could we please therefore come back at 2:15?
2:15. Right. Well, sorry. Very well. Yeah, we'll resume at 2:15.
Thank you very much. Good afternoon, sir. Can you see and hear me?
Yes, I can. Thank you.
Thank you. Mr. Parsons, we're going to move on to a few separate topics, the first of which is second sight. Could we start, please, at WBON 40767? So we'll start on the 12th of July 2013. If we scroll down, there is an email from you to Susan Crichton. And you say as follows: Susan, had a quick chat with Gavin. Who was Gavin? Is that Gavin Matthews?
Correct.
And what was his position?
He was my supervising partner.
Yes. Arbitration will probably end up as formal and long-winded as court proceedings. We'd also lose a degree of control. The process and timing would be controlled by the arbitrator. I'm not attracted to this. So they're discussing options. One is arbitration, another is mediation. And you come on now to address mediation. And you say, mediation is a definite possibility. I could envisage a mediation between the post office and each sub-postmaster, with also second sight in the room, and perhaps shoesmiths. This gives each sub-postmaster the opportunity to voice their views and discuss second sight's findings. Having a mediator in the room would help equalise the imbalance of power. Mediation would not commit the post office to any outcome unless one was agreed by both parties and could be conducted on our timetable. If the mediations were run after Second Sight's final report, this may help ensure that the report focuses on general themes whilst leaving specific cases to be heard in the subsequent mediation process. The risk in that is that mediation is usually set up with a view to reaching a resolution. As discussed yesterday, I doubt we will ever reach closure on these cases. The Post Office's comms team would therefore need a robust media strategy to explain why the mediations will, in the majority of cases, fail to reach a consensus between the Post Office and the sub-postmaster. Otherwise, this will be spun as a failure to close out this matter. It seems as though there was a discussion the previous day then about mediation. Do you recall those discussions?
I recall that during this period there were a number of discussions about different ways of taking things forward after the second sight interim report, of which mediation was one of the possibilities.
Now, why would mediations in the majority of cases fail to reach a consensus?
My understanding at this point in time is that there was a large delta between Post Office's view of the world and the sub-postmaster's view of the world.
We know that it did go to mediation ultimately. What was the purpose of mediation if there was this large gulf that was unlikely to result in any resolution?
So the shape of this moved on after this email into a slightly different shape of scheme where the cases would be re-investigated first and then mediated, which I thought would close the gap between the two parties and give mediation more of a prospect of success.
Could we please turn to poll 00191954? Shortly, same day in fact, 12th of July. If we turn to page 4, we can see there that Alan Bates has been in touch addressing matters that have been discussed. It comes to a point in where you are advising, if we turn to page 1, please. He made some suggestions on how the mediation scheme might be conducted. And then we have your advice to Susan Crichton here. You say, Alan's approach seems similar to what we discussed yesterday. However, there are some critical differences. Second sight seem to be being used as a weapon by the Justice for Sub-Postmasters Alliance to force Post Office into settlement. That is not their job. The approach assumes that the Post Office is liable and will offer settlements and seems to hint at cash settlements. I'm not sure where Second Sight have got this idea from. Any hint that the Post Office may be considering cash settlements would encourage the toxic cases, encourage shoesmiths, and play badly in the media. I think we need to put a stop to this quickly. Let's just unpack that paragraph, please. First of all, cash settlements. It seems as though you're surprised by the suggestion of cash settlements in the summer of 2013. Why is that?
I think if I can't see Alan's email here, but I think the scheme that he was envisaging was more of a compensation scheme, whereby there was a sort of almost a presumption of liability, and it was just then about compensating people. Whilst at this stage, Post Office wasn't in their instructions weren't that they weren't prepared to accept liability across a wide piece.
What is the purpose of mediation if there isn't going to be a financial settlement at the end of it?
There could possibly be a financial settlement at the end of mediation, but as I say, I think Alan's proposal, which is further down this email chain, wasn't a mediation proposal. It sort of assumed more of a compensation scheme structure.
Any hint that the Post Office may be considering cash settlements would encourage the toxic cases? Just pausing there, that's an expression we've seen elsewhere. Can you assist us with what toxic cases were?
I think that was Alan's choice of words to describe what he saw as particularly difficult sub-postmaster cases.
So they would be encouraged by the idea of cash settlements, encourage shoesmiths and play badly in the media. I think we need to put a stop to this quickly. Just reading that, what would be mediation would at some stage presumably lead to some cash payments to sub-postmasters, wouldn't it?
Yes, but as I said, I think Alan's email below isn't really talking about a mediation type structure. It's talking more about a compensation scheme structure that assumes liability. So they're two very different concepts. And I was concerned here with Post Office conceding the liability point and assuming there would be cash settlements in every case.
We're going to move on to December 2013. Could we please turn to poll 003271110? It's an email to you, from you to Martin Smith, Jarnell Singh and Roderick Williams. Martin, Jarnell, Roderick. As discussed last week, below is our next thorny question on the interaction between the mediation scheme and criminal prosecutions. We now have 4 cases in the scheme subject to live criminal investigations/prosecutions. Thus far, we've refused to provide any details of these cases to the working group. However, the working group are concerned that as they have no oversight on these cases, there's no way for them to validate that and that the applicant's application to the scheme should remain suspended. Underlying this is a general and, in my view, unwarranted distrust by Second Sight and the Justice for Sub-Postmasters Alliance of how the Post Office handles criminal cases. We've spoken a lot today about how, in your view, you had a very hands-off approach to the criminal cases. How is it that you formed the view that their distrust was unwarranted?
I can't recall this particular email or what drove that thought.
Presumably you had a sufficient knowledge of how the criminal cases were being addressed to write in an email that it was an unwarranted distrust.
All my knowledge about the criminal cases was passed to me by the criminal lawyers. I never reviewed any of the criminal cases myself.
But you didn't say, in Cartwright King's view, it's unwarranted. You had formed a view by this stage about the trust that should be placed in the Post Office's handling of criminal cases. How did you form that view?
Based on the information I'd seen from the criminal lawyers.
And did you just assume that what they had told you was correct in that respect?
Yes, because I was relying on them to provide me with that information.
Could we please turn to poll 00201-761? We're now in March 2014, the 13th of March. And this is an email from yourself to Roderick Williams. If we actually scroll down slightly at the bottom, you can see there he is asking you, he's says, what are your thoughts on how we should feed to Second Sight's Fujitsu response below on Second Sight's MO14 report? So that's a specific review that Second Sight are conducting. If we scroll up, please, you say as follows. Roderick, I think we hold fire until we see the thematic report. So by this stage, Second Sight were working on a second report that addressed themes. Is that correct?
Correct.
Yeah. At the working group meeting on Friday, Second Sight hinted that their concern is not a comms failure between branch and data center, and therefore a failure to record transactions to the audit log in the DC, but rather it was where a third-party system received the transactions, but there is a comms failure that stops the transaction completing at the branch end. They call this the one-sided transaction issue. The point is not expressly drawn out in M014, but does come out more clearly in M001 Castleton. You then say this, the variation on the comms theme is not directly covered in the Fujitsu data integrity documents, so we may need to commission further work from Fujitsu once we know for certain how Second Sight have characterized this in their thematic report. On that basis, I think sending more information at Second Sight at this stage risks them asking more questions. My preference is for a targeted attack on the Second Sight report when we understand the specifics of their position, rather than be on the back foot in trying to defend the entire Horizon comms infrastructure. Second Sight were a firm of independent investigators that had been instructed by the Post Office to carry out that independent investigation. Is the approach that you're taking here very similar to the approach in litigation? A targeted attack on their report. I mean, it does seem rather adversarial, doesn't it?
Yes, I accept it that I adopted a reasonably adversarial approach.
And was that based on instructions, or was that the way that you saw it should be approached?
It was a combination of my doubts at this point in the quality of Second Sight's work, and that was the general direction and theme that Post Office were taking.
And who was setting that direction and theme in your view?
The group of individuals I was talking to on a daily basis about the scheme, so Roderick Williams, Belinda Crowe, and the other members of the Project Sparrow team.
When the scheme was set up, did anybody ever tell you, for example, this is intended to be like a Truth and Reconciliation Commission or something along those lines, where we're not to take an adversarial approach?
I don't recall anything along those lines.
Could we please turn to Pol 00305714? We're moving now swiftly to the summer of 2014, 11th of August, and there is a meeting. Second Sight's draft Part 2 mediation briefing report. It's a teleconference. Amongst the participants, you're listed there as the representative from Bond Dickinson. Do you recall that meeting?
No, I don't.
Let's have a look at the notes, the record of that teleconference. Could we go, perhaps let's look at page 3, please, the bottom half of page 3. Thank you. Lack of evidence. Second Sight expressed concern that the character of the conversation is one of litigants, antagonistic. And that's a fair reflection of the approach that you've just described, isn't it?
I think it waxed and waned. So there was certainly a period of time at the beginning where we were very much looking to cooperate with Second Sight, provide as much information as we could, particularly in the individual cases. At times it became more adversarial, and then at times we tried to row that back again because we realised it had got too adversarial. So I think it moved during the course of, the 18 months that the scheme was running.
Second Sight claimed this is the antithesis of what the CEO and chair assured them would be the case. Were you aware of any discussions or instructions from the CEO and chair about how the scheme should be conducted?
Don't recall.
Post Office reassured Second Sight that the conversation is not antagonistic. Post Office expressed concern about Second Sight not getting to the truth of the case and not providing evidence. Post Office stated, not trying to fetter Second Sight's independence or take things out, just want to get the paper right. Post Office expressed concern that the lack of evidence doesn't take things further. Post Office concerned applicants may feel issues are more widespread than they are. Second Sight claimed they report the truth with an objective to help the applicants. We scroll over. Post Office raised 2 examples of items that are out of scope, contractual and criminal. If you look at criminal matters, need to ask why and who are you doing this for. Just looking back at the attendees, there was nobody from Cartwright King at this meeting. You were the only external legal advisor at the meeting. Were these likely to have been your words, or a summary of your words?
I don't recall this call, and I think this document was only sent to me a few days ago, so I haven't had a chance to look into it.
Post Office flagged the risk of straying into legal, layer upon layer of legal argument, dangerous ground to comment on contract, applicants may rely on as legal advice. Post Office suggested if there are areas Second Sight are not qualified to investigate, that might be an issue for Post Office to look at. Had the scope been criminal or contract, wouldn't have employed accountants. Second Sight concerned late in the day to mention out of scope. Don't recall anyone raising this previously. No one previously cried foul. Post Office responded that this is not about crying foul. Raising now as out of scope has first raised as a material point. You may not recall this exact meeting at which you were attending, but can you recall in the summer of 2014 those kinds of real tensions between the Post Office and Second Sight?
Those issues around scope were points of tension. Post Office thought that Second Sight were exceeding their scope by including commentary on legal issues within their reports, where Post Office had attempted to run the scheme without advancing legal defences, certainly during the investigation phase. But alongside this, there was also a lot of cooperation in terms of providing information to Second Sight.
If we scroll up, it's not just scope, there's the section on lack of evidence. And it said there, penultimate paragraph, Post Office expressed concern that the lack of evidence doesn't take things further. Post Office concerned applicants may feel issues are more widespread than they are. Is that a concern that you recall at that time? A concern at the Post Office that Second Sight might be giving the impression that things are more widespread than the Post Office thought them to be.
I don't recall the last bullet point being discussed with me.
You were at this meeting, though.
As I say, I don't recall the meeting.
Do you remember that being a concern?
I don't recall that idea coming up.
Could we please turn to poll 3075810? Moving now to the 16th of October 2014. There's an email, the second email on that page, please, if we scroll down. An email from yourself to Anthony Hooper, so the chair of the working group, and you say, on our last working group call, you asked Post Office to make clear which cases it considers are suitable for mediation before the face-to-face meeting tomorrow. You asked Belinda to ensure that this information was copied to Second Sight, so I have copied in Ron and Ian. Having carefully considered Second Sight's final CRRs, that's the questionnaires. Is that the questionnaires, CRRs?
No, that's the Second Sight report.
The reports. Post Office's position on mediation is set below. We will explain at the meeting tomorrow our reasons for taking these positions. So you've been asked to identify which cases you consider are suitable for mediation, and you have responded to the chair of the working group, and we have there set out the Post Office's position on mediation. Could we please look at that? So if we scroll down slightly, number 1, unsuitable. Number 3, unsuitable. Number 5, currently minded to consider unsuitable. 17 unsuitable, 21 unsuitable, 29 unsuitable, etc., etc., etc. At that point, all of the cases were listed by yourself as being unsuitable for mediation. Do you recall that?
I'm trying to think if there was any commonality in those cases that led to that decision, because this is towards the end of 2014. The cases which were suitable tended to move through the scheme quicker, so they may well have already passed through, and what was left were the ones which were more heavily contested, where Post Office thought they were unsuitable. So the fact that that list is nearly all unsuitable may be a product of where we are in the scheme at that point in time.
If we scroll up slightly, on our last working group call, you asked the Post Office to make clear which cases it considers are suitable for mediation before the face-to-face meeting. So you've been asked which are suitable, and your response is, in effect, all of them are unsuitable.
Well, I suspect at this point in time, these were the cases that were pending decision on whether to go to mediation. So by the end of, can you scroll up ever so slightly so I can see the date? So October 14, at this point, the cases would have all been at different stages. Some would have still been waiting in investigation, some would have been investigated by Post Office, some would have been investigated by Second Sight, and some would have probably already gone through to mediation. So I think that's just a snapshot in time of those cases.
Do you think that in reality, by that stage of 2014, this was a properly functioning scheme?
I think it began to break down, well, the working group began to break down around this time and towards the end of 2014.
Because the working group was meant to determine which ones were suitable, and at least on the face of this email, it's not actually receiving any that the Post Office considered to be suitable.
But as I say, this is a snapshot. There are, how many cases are there? About 10? There are 150 cases in the scheme.
Could we please turn to poll 00141727, please? Still in October, 31st of October now. An email from you to Patrick Bork. Patrick, in recent CRRs, I've noticed Second Sight using language such as the Post Office has failed to disprove the applicant's assertion. See para 4.2 attached for an example. This is building in a presumption that the applicant is correct and that the Post Office has to disprove the position, even where the applicant has put forward no corroborating evidence. This will lead to the Post Office losing a lot of battles. I think this may be a point to raise with Second Sight on our next call, as it's not within their gift to apply an evidential presumption in favour of the applicants. If anything, the presumption should go in the Post Office's favour, given that we are notionally the defendant, and two, no one has yet proved a flaw in Horizon. Again, real tensions in that period between the Post Office and Second Sight, it seems.
There were tensions during this period. I would just note that the way Second Sight were asked to produce their reports by the working group is they were required to give an opinion where there was evidence and then identify issues on which they didn't believe there was sufficient evidence to offer an opinion. So the concern here is they weren't using the structure that was set by the working group.
They weren't, sorry?
Using the structure for their reports that was set by the working group.
I think Sir Anthony Hooper's evidence of this inquiry was he wasn't particularly concerned by the paperwork coming from Second Sight at this stage. Would you take a different view?
I didn't see Sir Anthony Hooper's evidence. I apologise, I'm not quite sure what the context was for his comment.
Is your evidence that you personally had concerns about Second Sight's paperwork as at October 2014?
I had concerns at that point about the quality of the work product they were producing.
Could we please turn to poll 00176599? 7th of November 2014. This is an email that the inquiry's seen before. It's from Martin Smith to yourself and others. And he says, from a criminal perspective, we would advise as a general rule against the disclosure of any documents from a criminal file which had not previously been disclosed to the defendant during the course of the original proceedings. To do otherwise may well enable the defendant or second sight to attempt to criticise the way in which the prosecution was conducted or how the prosecution policy was applied. Clearly, such arguments in a public arena would be uncomfortable for the Post Office. Did that raise any concerns for you?
My recollection is that we, WBD on the WBD side, looking at it from the scheme perspective, were keen to use the material in those files because we thought it helped explain the cases, and Martin and Cartwright King were pushing back against it. I think ultimately that question was taken up to the working group, and Sir Anthony gave some directions on how to proceed.
Could we please now look at poll 00214-323, 9th of December 2014. Second Sight have provided a list of questions that they are seeking answers to. You can see there's attachment Second Sight questions for the Post Office. And this is an email from yourself to Belinda, Crowe and others. And you say as follows: there are some sensible questions in here, but there is also a massive fishing expedition for information that does not address issues raised by applicants. I've highlighted all the questions that I think are just fishing for info in blue. There are also a number of questions that are outside the scope of the scheme. Most telling is the fact that there are only a handful of questions about Horizon. Nearly all the questions are about accounting practices. I think you've accepted already that Second Sight were the approach that the Post Office was taking was adversarial in nature. Is this an example of that? Because, of course, Second Sight had been appointed as independent investigators. They've made a request to the Post Office for information, and you, a lawyer on Post Office's behalf, have gone through that and reached the view that it's what you might call a fishing expedition in litigation, and are addressing there which ones should and shouldn't be answered.
So as I said earlier, the adversarial nature of it waxed and waned over time. Here I'm expressing concern about some of the questions, but my understanding is actually that a good number of those questions, I can't remember the exact amounts, were actually answered.
We can have a look. I can take you, if you'd like to, well, I may be able to take you to that document perhaps tomorrow morning. But is your approach here particularly adversarial, given that Second Sight had been appointed as independent investigators?
No, I don't think so. I'm just advising Post Office on what I think is the relevance of the questions. And then if you look at the last part there, it says, my guess this is going to take quite a lot of work to answer all these questions. And I recall that it was quite a lot of work, but a lot of the questions were answered.
Well, let's have a look at that. Can we look at poll 000218663, please? Same month, December 2014. I think we're on the 29th of December now. If we turn to page 3, please. Belinda Crowe emails. She says, Mark Poole / Andy Parsons, would you be able to prepare the schedule of questions to which the Post Office is not prepared to respond and the reasons why? It would be that some of the text I've included in the letter is best placed in the schedule. So there's a letter that's being prepared to Second Sight in relation to the questions that they've asked. If we scroll up, please, there's a response from Mark Underwood. He says, hi Belinda, as requested, please find attached a list of questions we are not providing answers to and the reasons why. Andy, there's one question I've highlighted. Did we actually ever send out the response with regards to the suspense accounts, as I am unsure? In total, we're not providing answers to 41 of the 110 questions posed, 37%, split by reason in the table below, and he sets out there a table. So I think your evidence just before was that you did provide answers to lots of the questions. 37% of those questions you weren't answering. 25% because you considered them to be phishing. Why even use phishing as an expression in relation to your independent investigators?
Oh, this is Mark Underwood's assessment of those questions. I know that this actually went through a two-stage process. So I think this is version 1 of the answers. And then there was a discussion with Second Sight, I recall, where they clarified some of the questions. There was a discussion at the working group where the working group advised that some of the questions were too wide, and a version 2 was produced with a lot more answers.
Would you accept that that's quite a high percentage of questions not being answered at that stage?
At that stage, yes.
If we scroll up, we can see your response. And you say, I've tried to flesh out some of the reasons so that it doesn't look like we're just stonewalling. I also think there are a few questions we may be able to answer, or at least fudge an answer. I think it would be better to try and answer a question than just refuse entirely wherever possible. So were you trying to push the post office to at least answer some more questions?
If possible. From memory, some of the questions were very wide, to the point where they were, it would require disproportionate effort. And what I was trying to encourage Post Office to do was at least try to answer a question, even if they couldn't provide a full answer.
You asked to see the questions and the I think the table, and I can actually bring that onto screen. That is poll 0002184. Is this what you had in mind?
No, I had in mind the actual final version of the answers that was sent at the end of January.
Okay, well, this is the table that was attached to that email that I've just taken you to, where you've used the word fudging an answer. And we can see 4.6D, for example, the question is, Second Sight are asking Post Office, any instance in the last 3 years in which Post Office initially determined that a cash loss was attributed to a sub-postmaster, but where it was subsequently found that the sub-postmaster was not responsible for the loss. And the reasons for not providing an answer is requesting general information on the occurrence of certain events without reference to it being raised by the applicants. And somebody has inserted their note. I think we could fudge the answer to this as follows. If we scroll down. As explained to Second Sight previously, sub-postmasters can challenge any cash loss or transaction correction in their branch in relation to ATMs. In many circumstances, the information needed to determine the cause of any discrepancy is only held by a sub-postmaster. There will therefore have been occasions when a transaction correction against a sub-postmaster has been challenged and reversed. This is, however, standard operating practice. Can you assist us with who would have inserted that suggested form of words? If we scroll out again, we can see the reference. I mean, in your email, you referred to maybe able to answer or at least fudge an answer. And if we scroll up, we can see it says, note, I think we could fudge the answer to this as follows. Does that suggest that that proposed answer is coming from you?
It may have been, but I only provided this document a couple of days ago, so I haven't had a chance to consider it.
Is it likely, given that you've used the word fudge in a covering email on the same date, that is, in fact, coming from you?
I think that's possible, yes.
Why, taking that as an example, why is it that would have been something that couldn't be answered by the Post Office in response to a request from Second Sight?
So my recollection is that Post Office was only given by the working group a very short period of time to respond. I think it might have been a month. I may have that wrong. And if you look at that question, it says, any instance in the last 3 years in which Post Office initially determined that a cash loss was attributed to a sub-postmaster. That is a very large period of time to cover across 10,000 branches. So my view is I don't think it would have been practical to be able to get to the bottom of that answer within the time available.
And why wouldn't that have been the response? Why did you feel a need to fudge an answer to your independent investigators when the explanation could well have been, as you've just said, that is not reasonably practicable in the time?
Well, I think the answer that's given there is trying to assist them and to give them a steer as to why this information may not be relevant or needed. But I'd have to see the final version of the document to decide where we actually ended up with this.
Is fudging a steer, or is fudging?
No, I think we couldn't answer the question because there wasn't enough time. I think the answer given there, which I'm just reading again now, I think is an attempt to try and give a steer as to what Post Office's position was. Isn't
it yet again taking a particularly adversarial approach to the independent investigators?
Again, I don't know what time this document was. Sorry, I lost the date. I think you said it was 2014. My recollection is that after this, there was a meeting with Second Sight to discuss the questions that couldn't be answered, to try to reframe them, narrow them, recast them if needed, so that Post Office could then answer them. So yeah, I accept that to an extent this is adversarial, but it's also, as I say, it waxes and wanes, and then there's periods of cooperation as well.
When, in your view, did it wane?
Well, for example, sitting down with Second Sight and talking through these questions and trying to get to a mutual position on them.
Could we please turn to poll 001504660? We're still in December 2014, the very end, 31st of December 2014. And there has been the Westminster Hall debate, and the Post Office is formulating a response to a case related to the Members of Parliament's queries. You're emailed by Melanie Caulfield, who, if we scroll down slightly, she's emailing you and Angela van der Bogaard and others. She says, on the criminal cases, the main message to land now that Post Office investigations are completed is our view that there is nothing that undermines the safety of convictions, but legal routes have, of course, never been closed to people. This will be unpalatable in the extreme to some, and any meetings will certainly be made public, so we need to be in a position where we can release supporting non-case specific documentation to counter inevitable allegations as much as possible. So on the criminal cases, the main message to land now that the Post Office investigations are completed is our view that there is nothing that undermines the safety of convictions. What investigations did you understand that to be referring to?
I think that's a reference to the investigations through the mediation scheme.
And having been somebody who was involved in the mediation scheme quite heavily during this period, is it your view that the result of that mediation taking place was sufficient for the Post Office to form a view that there's nothing that undermines the safety of convictions?
Every case in the scheme, the investigation reports for every case in the scheme went to Cartwright King for review, and I don't recall Cartwright King raising anything in those reports that caused them to question the safety of a conviction.
I'm going to move to the proposed termination of Second Sight. Could we please look at poll 30222352? We're now in February 2015, 5th of February 2015. Patrick Bork emails you, and he says, Dear Andy, we spoke briefly. I would be grateful if Bond Dickinson could produce a short bit of advice on the manner of implementation and consequences of a future decision to terminate Second Sight's engagement. The advice needs to cover, but should not be limited to, if other matters occur, the nature and extent of the Post Office's ability to control access to and uses of all and any information it has provided Second Sight, the duration and effectiveness of that control, in particular with regard to the Part 2 report that they are preparing, and the legal and practical effects of the 30-day notice period which the letter of engagement provides for. I'm also interested in the effects in legal and practical terms of a termination, given that the letter of engagement tries to make it clear that although they are engaged by us, they in fact work to the working group. You can imagine the sorts of arguments which might be made. Now, this is very shortly after the Select Committee appearance of Second Sight and Paula Venables. It seems from this email, were you aware that it was the intention of the Post Office from this point to terminate the contract with Second Sight and not to have a Part 2 report?
Either shortly before or shortly after this, I think I was provided with I can't remember if it was a board paper or a steering group paper about the termination of Second Sight. So I was aware that that was the direction of travel that Post Office were heading in.
And were you aware that one of the reasons why they wanted to terminate Second Sight at that point was before the Part 2 report could be completed?
The second version of the Part 2 report, the first version had already been produced by this point. I don't remember it about stopping the Part 2 report. I remember the concern was more about ensuring that Second Sight focused on completing their investigations into individual cases before they focused on the Part 2 report.
Shall we look at the advice that you gave? That's poll 00006364. Thank you. It has Bond Dickinson on the final page, 6th of February 2015. Is this an advice that you wrote?
Yes.
If we scroll down, please, there's a section on contract termination. So the contract between the Post Office and Second Sight is governed by the engagement letter dated the 1st of July 2014 and a side letter. If we scroll over the page, please, to Second Sight's position during the notice period. Here you're addressing the position of Second Sight during that 30-day notice period. And you say as follows: under the engagement letter, Second Sight is required to continue providing the services until the end of the 30-day notice period and is entitled to be paid for any work done. There is, however, no converse obligation on the Post Office to keep asking Second Sight to do work during the notice period or at any time. Second Sight may try to argue that they have a right to continue to work during the 30-day notice period. We consider that this argument would be difficult for Second Sight to advance. First, the terms of the letter simply do not provide for this. Second, effectively, Second Sight would be arguing that there is a minimum guaranteed volume of work due to them where no such guarantee was ever given. Third, Second Sight are paid on an hourly rate, so their pay is not conditional on the completion of work. One complicating factor is that the services include Second Sight assisting with any reasonable request made by the working group and/or Post Office. Although the working group has no legal standing to enforce the engagement letter, decisions of the working group can nevertheless influence Second Sight's work. If during the notice period the working group were to direct Second Sight to complete some work within the scope of the services, then Second Sight would be entitled to complete this work and expect payment. To avoid this situation, we would therefore recommend that in tandem with the termination of Second Sight, the working group is also disbanded so that it cannot give any directions to Second Sight. This will then enable Post Office to direct Second Sight to immediately cease all work. You've given in your witness statement a number of reasons why it was a sensible idea to terminate the working group. But is looking at this now, is a significant consideration in the disbanding of the working group that the effect of that would be to stop Second Sight from carrying out any further work?
This advice was from the legal perspective on that decision. And from a legal perspective, if Post Office wanted a clean exit, then it seemed to me that they needed to disband the working group as well. And
had you had discussions with the post office that their intention was to end second sight's work and to prevent them from being provided with any other instructions by the working group?
No, that wasn't my understanding. My understanding is they wanted to bring to an end the current arrangement and replace it with a new arrangement that could see Second Sight complete their work. I can't now recall whether that explicitly included Part 2 or not.
Let's look at the disbanding of the working group. Can we please turn to poll 000210908? There was a draft paper that was circulated for Sparrow subcommittee. We see that if we scroll over the page, on page 2, Mark Davis is sending a first draft of that paper. We then have, on page 1, your views. I'll just take you to a few passages from this email. Belinda, a few thoughts below on the Sparrow paper. In general, I agree with the idea of disbanding the working group as, 1, it offers no real value, and 2, it is the source of much of criticism of the post office. However, I see some challenges with the other 2 limbs of the proposal, and you then go on to address those 2 limbs. First is Second Sight's role. And you say, if Second Sight are independently contracted by applicants, then I cannot see how the post office can dictate Second Sight's scope of work. So one of the proposals was to let applicants themselves appoint Second Sight. Is that correct?
Yes.
And your view was that that was not sensible because the post office would lose control?
Yes, in particular in terms of timing, because the great difficulty to this point was that Second Sight were a long way behind schedule.
If we scroll down, we can see a second suggestion, mediating all non-criminal cases. And you say as follows, mediating all non-criminal cases, of course, means mediating lots of hopeless cases. Mediating unmeritorious cases raises applicants' expectations unfairly and may in fact create greater animosity and complaints. Certainly that was my experience from MO02. My recommendation would be for the post office to take a tougher line and only mediate meritorious cases, even if the bar for this is set low. Just pausing there, wasn't that the very purpose of the working group itself? To vet those applications, to work out which were meritorious so that they could go forward?
That's what I expected at the outset. However, through a series of decisions of the working group during the course of 2014, Sir Anthony Hooper decided to take an approach which lowered the bar on whether cases should go to mediation or not.
And did you disagree then with Sir Anthony Hooper's approach?
I did disagree with that decision, yes.
Aren't you here, though, suggesting imposing a bar, albeit a low bar?
The distinction here is that the working group were prepared to put cases through to mediation where the sub-postmaster had been convicted. That created a problem for Post Office because it had been advised by its criminal lawyers not to mediate with anyone with a conviction. And that tension, in my view, was probably the root cause of the working group breaking down at the end of 2014.
We saw earlier that email where I know you said it was just a snapshot, but a very high number of cases that had been deemed unsuitable by the Post Office. Mm-hmm. How do you get from a position where you are determining that a large number are unsuitable to saying, actually, we'll mediate all non-criminal cases?
So again, I think you have to be careful with that list because I feel it may not be I think it may be a subset of sub-postmasters. I recognise some of the numbers on those lists, and I think a number of them were sub-postmasters with convictions. I can't remember all the names and the numbers now, so I wouldn't draw anything from that list. I think this is a proposal here to say Post Office should be looking to mediate meritorious cases even if the bar is low.
Reflecting now on all of those emails and just your recollection of that mediation process, do you think that the process itself was doomed to fail?
No, I don't believe so. I think people went into it in good faith. I think the breakdown of, I think the relationship with Second Sight could have been better between Post Office and Second Sight. I think that could have been more collaborative. I think that would have required more compromise on both sides to reach that stage. but I still think that the mediation scheme did a lot of good.
Do you think, reflecting on it, you personally should have taken a less adversarial approach?
Towards Second Sight, yes. With hindsight, I think there were some points where we were fair in criticising Second Sight, but there were some where we were too adversarial.
I'm going to move on now to the topic of remote access. I'll go through a few documents and then we'll take our mid-afternoon break. But then I'll stick with remote access probably for the rest of the day. It's possible that I might move on to one other topic before we finish for the day. Could we start, please, with poll 000314456? So we're starting 1st of February 2015, and there are discussions with Melanie Caulfield and Mark Underwood. If we scroll down slightly, actually, if we could, let's start on page 3. Melanie Caulfield emails Roderick Williams. What would be the circumstances for Post Office adding a transaction? We did so once since 2010 using functionality. I know very rare, strict authority, but will we need to ever do this? If we scroll up to page 2, there's an email from yourself. If we scroll up slightly more. And you respond to say, Mel, sorry, we've never got any clarity of this point. The reality is that the use of the manual balancing process is so rare that there is no protocol for its use. If we scroll up, we see more correspondence on the issue. Page 1, the middle of page 1, and you're still involved in this email chain. Mark Underwood to Melanie Caulfield and yourself. Mark Underwood says, it comes back to Andy's point about the question being wrong. Access can mean view. The question is, can transactions be edited remotely? To which the answer is no. Once a transaction is in, it cannot be removed or edited in any way. All that can happen is for additional transactions to be put in to correct mistakes, all of which are visible to the sub-postmaster. Now, we know now that that is wrong. If PV and MD, that's Paula Vennells and Mark Davis, are still confused, I would just send them the below extract from the paper, as I think it makes it quite clear what can and cannot be done. Alternatively, we treat any questions about remote access with the contempt they deserve. Why on earth would Post Office have a secret bunker in Bracknell accessing sub-postmaster accounts? And then it sets out there the issue and the response. If we scroll up, we see a response from Melanie Caulfield. She says, at one time, our line was simply that there is no remote access, but for most people, I think that sounded unlikely given that you have to have full support, etc. It has a different meaning for different people. I completely agree re showing contempt about the allegations on this subject. It's a prime example, actually, of our rigour in investigating allegations that are in the realms of fantasy. What was your view on receiving those emails?
It appears to me that Mark Underwood has set out factually what we understood the position to be at that time. Admittedly, that was wrong. The language around treat with contempt, I think is probably too strong.
Did you think that at the time, or were those the kinds of emails that you would receive on the topic of remote access?
I think at the time people thought it was a very unlikely possibility that remote access was the actual cause of losses in branches. And at this time, going through the mediation scheme, determining the cause of a loss in the branch is the central question. So people generally thought, including myself, that remote access was never going to really move forward these cases. through the scheme.
Could we please turn to poll 003127443? The bottom of page 1 over into page 2. March 2015. We've been through the prosecution file for MO56 Wiley. There will be further documents to disclose, including the attached witness statement by Gareth Jenkins. At the top of page 3, Jenkins states, "I also note a comment made about it being possible to remotely access the system. It is true that such access is possible. However, in an analysis of data audited by the system, it is possible to identify any data that has not been input directly by staff in the branch. Any such change to data is very rare and would be authorised by Post Office Limited. As I have not had an opportunity to examine data related to this branch, I cannot categorically say that this has not happened in this case, but would suggest it is highly unlikely." And you say as follows, you say, "I'm pretty certain that Jenkins is referring to balancing transaction process that allows Fujitsu to input new transactions rather than edit old transactions. Nevertheless, this will be a red rag to Second Sight." Why would it be a red rag to Second Sight?
Because they were concerned about anything around remote access.
And the suggestion here being not just that old transactions can be edited, but that new transactions can be input.
Correct.
Thereby adding some substance to the allegation of remote access, potentially.
It would add substance to the question of whether it was possible or not. I don't think that would change the question of whether remote access was actually a probative cause of losses in branches.
If we scroll up, please. Roderick Williams to yourself, he says, "This is consistent with our responses/statements about remote access, isn't it? I.e., you can add data, inject a balancing transaction, and if done, it is possible to identify any data that has not been input directly by staff in the branch." And your response is at the top, "Not quite. We say that transactions entered by sub-postmasters cannot be edited, but we don't go on to say that Fujitsu can input new transactions in exceptional circumstances. This information would therefore be entirely new news to Second Sight." Were you by this stage quite concerned about the information that had so far been disclosed about remote access?
Yes. So when I first found out about the ability to inject balancing transactions, was back in 2014. I'd advised Post Office that they should give that information to Second Sight, and it's a point of regret for me that I didn't press them to do that much sooner than now.
And in response to this issue being raised in March 2015, are you aware of that information then being disclosed to Second Sight?
I think it was provided to them the next month.
Could we please look at WBON 301024? If we could start, please, on page 3, the bottom of page 3 into page 4. We're now in 2016, July 2016. You are emailing counsel Anthony DeGar Robinson, and you say over that page, your comments on the letter of response. So at this stage, you're on the letter of response to the group litigation. Is that right?
Correct.
Are understood and very helpful. We'll work the general structure of the letter and then come back to you to discuss specific points. Off the back of yesterday's call, I think I now have a better grasp of the central tenets of our case. I've tried to capture these below just to see if it matches your thinking. And then it's at 2 that you address remote access. So the branch accounting system, including the role of Horizon within the accounting system, is built around the principle that postmasters approve every transaction that goes into their accounts. A, they or their assistants enter all transactions conducted in branch, and B, they or their assistants approve any transactions originating from the post office, such as transaction corrections. And in brackets, it says as follows, note, the issue of remote access is critical here. My understanding is that the post office will not use a balancing transaction without postmaster consent, in which case this complies with the above principle, but we need Deloitte to confirm this. And it says absolutely. Are you able to assist in whose words those are? Is that your email, or is that somebody inputting into your email?
I can't tell.
Certainly by this stage, the summer of 2016, you recognised the critical nature of that remote access point.
Yes.
Poll 3029990. We have an email from yourself to Jane McLeod, Roderick Williams and others. Further to some Deloitte investigations. Before tomorrow's steering group meeting, I wanted to give you a heads up on remote access issues. Deloitte has identified that a small number of super users at Fujitsu have the ability to delete and edit transactions from the branch database. The branch database is the central server on which all branch transactions are recorded before being passed to other servers. The access is subject to strict controls, and Deloitte's current understanding is that it would not be possible to delete or edit transactions without leaving a footprint in the audit trail. They also believe that 1, this type of access is not unusual, and 2, the likelihood of someone actually making such changes is extremely low. The super user access is a separate yet more extensive process to the balancing transaction process we previously knew about. Then you go on to identify what the issue is. The immediate concern is that this means the post office's historic statements about not being able to edit or delete transactions appear, at least on face value, to have been materially incorrect. This therefore may bring into play 1, allegations of deceit in the post office has made false statements, 2, a basis for unwinding the settled cases, 3, the possibility for some claimants to extend their limitation deadline. If we scroll down, you say, once we have a much clearer picture, we may wish to seek Brian Altman's advice on whether this issue causes any concerns for criminal law / disclosure perspective. We may also need to give consideration to whether to inform the Criminal Cases Review Commission. So first of all, this is presumably quite a significant moment for you, having been involved in the issue of transaction corrections for quite a number of years now.
The issue of balancing transactions.
The issue of super users.
So yes. Well, we were, by this point, I'd been provided with copies of Deloitte's earlier reports and the SWIFT review, which pulled this issue out. So this is further investigations by Deloitte.
You've identified there under issues, slightly further up, some civil issues, but then you refer also to seeking Brian Altman's advice and the Criminal Cases Review Commission potentially having to inform them. Is this again an example where, although you are not, as you've said many times, the criminal law expert, you are touching upon matters that affect the criminal law potential appeals?
Here, yes, because I also recall that a year earlier we had already got Brian's advice on the remote access issues.
Thank you. So I will be continuing with more questions on remote access, but perhaps that is an appropriate time to take our mid-afternoon break.
Yes, by all means.
If we could come back at 25 minutes to 4.
Certainly.
Thank you very much. Thank you. Can we please turn to poll 00245978, please? The bottom of the first page into the second page, please. We're now on the 27th of November 2016, and you have drafted a letter to Freeths in response to their last substantive letter. And you say as follows: the majority of this letter addresses legal and procedural points. The key substantive area is section 9 on remote access. Following feedback from Deloitte, we cannot definitively say that the post office, as distinct from Fujitsu, never had the ability to change Horizon data, because Deloitte and the current staff at Fujitsu just don't have enough knowledge of old Horizon to confirm this. This was a point made in an early draft, but it has now been removed. We have, I hope, now found a formulation of words that avoids having to overly throw Fujitsu to the wolves and avoids any risk of waiving privilege in any documents, but still gives us a fair story to tell. What did you mean there by throwing Fujitsu to the wolves?
I think this letter is addressing not just remote access, but the statements that Post Office had made historically about remote access. And the view was that a lot of the previous incorrect statements about remote access were because Fujitsu had given us incorrect information, or had given incorrect information to Post Office.
Now, was that your view? Was that the view of the Post Office, or was it both?
Both.
You say, we have also toned down the admissions of making incorrect statements, though they're still there. I hope this might make it easier to get this letter cleared through the group executive and Fujitsu. So it seems as though Fujitsu are clearing the form of words that goes to Freeths. Is that correct?
Where we were writing letters on technical issues, then that type of language would go past Fujitsu to get their confirmation they thought it was accurate.
If we scroll up, please, we have a response from Rob Houghton. He says, I personally think we overdo the response on access, and I've suggested some changes. If we scroll up again, there's a response from Thomas Moran, also of Post Office. He says, my overall conclusion is that it could very well have serious implications on the proceedings, and we absolutely have to make sure we are briefing and securing the support of the right people internally before issuing. As I'm the lucky man with responsibility for this, as the steering group chair, I must ask that we get this properly reviewed by Mark Davis and also Angela, who I don't think are on the list. In particular, we need a full assessment and media plan based on the worst case consequences in place before sending. Can you assist us with the position within the Post Office, the concern at that time regarding the letter that was going to be sent to Freeths?
If it's the letter I'm thinking of, it was making concessions that Post Office had previously made incorrect statements about remote access, and that was the concern.
And there's reference here to Mark Davis.
Mm-hmm.
Was he somebody you knew?
I knew of him. He was the communications director.
How involved was he in these kinds of issues, from what you saw?
He would occasionally get involved in some of the legal issues that were coming up in the scheme.
Is it a fair reading of this correspondence that there was real concern within the business at this stage about this admission?
Yes, there was real concern about making this admission.
Could we please turn to poll 00415440? This is actually the day before that final email in the chain, but it all relates to the same issue, the same letter. It says, it's from yourself to counsel, and you say, Rod has gone through the remote access section. The content is broadly the same. He has reordered the structure, which I like a lot, and toned down the mea culpa, but I think this still works. Was that something that the Post Office was doing, toning down the mea culpa?
My recollection at this time is this letter does clearly state that Post Office made incorrect statements about remote access. There was some debate about the language that was used then to describe that situation, but I don't recall that was any real debate about the direction the letter needed to go in.
If we look at poll 002460005 at the bottom of that page, the bottom of the page, please. This is the 28th of November. Please find attached the updated remote access wording. The general direction of your comments was to be less apologetic in tone and less repetitive, both of which we've tried to accommodate in the attached. The key issue is how far we want to go in accepting that incorrect statements have been made in the past. I believe that some of the drafting/tone changes are coming out of us not having a settled view on this issue, and you suggest a call. So you say there the general direction of your comments was to be less apologetic. Where in particular was that coming from in your view?
I can't now recall. But we'd have sought comments on that drafting from probably the people on this email chain.
Moving into 2017 now, could we turn to poll 002495553? And we're now on to the drafting of the defence. So the admission has been made to Freeths in November 2016. We're now on to the defence in the summer of 2017. You are sending round the draft defence from council. If we scroll down paragraph 2, it says, paragraph 52, do we say that Pol previously relied on incorrect statements from Fujitsu in relation to remote access? This is basically dropping Fujitsu in it. Same point, I think, as before, really. It seems as though your view at that point was that Fujitsu were at fault or were to blame in some way, or that it was suggestive of that in the draft defence.
I felt that Fujitsu were primarily responsible, not solely responsible, but primarily responsible. And there was I recall there was some debate around exactly how we put that point in the draft defence.
Could we turn to WBON 40496, please? From Anthony Gar Robinson, you're copied in here, 10th of July 2017. Another version of the draft defence is circulated. If we have a look at paragraph 60, he says, the more I think about it, the more I think the whole of paragraph 60, other than the first two sentences, ought to be deleted. And there's reference to mediation, etc. in there that he doesn't want included. And it's the final line, final sentence there. It says, this seems to give us no excuse for not having researched the problem properly before we said remote alteration was not possible. Where do you consider the blame lies for insufficient research? It seems as though his view there was us being the post office rather than Fujitsu. Where do you think the blame lies for not having researched the problem properly?
I'm not sure whether Tony's using the word us to mean post office or Fujitsu or the collective side of the case that was the post office side of the case. Sorry, can you repeat your question?
What is your view, though? I mean, we're here, we're years later now, we're in 2017, we're still debating on how it's going to be phrased, the remote access issue. It's clearly an important issue to the business. You've placed a lot of blame with Fujitsu, but is it your view that the blame only lies with Fujitsu, or that there was a failure at the post office end to research the problem properly?
My view is it primarily sat with Fujitsu. I think There's probably some underlying problem with Post Office not understanding the Horizon system in enough detail across its organisation. And I also, to some degree, accept some accountability on my part because I feel I should have pushed harder on this issue during the scheme.
Could we please turn to poll 00249919? We're still in July 2017. And you send a email to council, a quick note so that you're in the loop on my meetings with the Post Office over the last few days. Both the Postmaster Litigation Steering Group and the Group Executive are comfortable with the defence by this stage. And you say, I've briefed both the Postmaster Litigation Steering Group and the Group Executive on what I saw as the key risk areas as follows. And then 2 is Horizon Integrity, Remote Access. Much more comfortable now we have Deloitte's work. Deloitte's view is that it is unlikely that data integrity / remote access is the true cause of the problems. The Post Office has previously made false statements, and we admit this, deny that that were known to be false when made. And you say this, both the steering group and the group executive are very uncomfortable about this, but understand the tactical reasons for this approach. Can you assist us with what you meant there?
I recall that senior management at Post Office were uncomfortable with making an admission that the previous statements had been incorrect.
Who do you have in mind there?
I can't place it to an individual because I would have been, at that time, I think, getting a lot of the feedback indirectly via the legal team, and I can't now recall these calls or meetings I had with the GE at that time.
But the message that was coming to you from the legal team was that the steering group and group executive were very uncomfortable about that.
Yes, and actually I can recall speaking to the steering group about it and getting that sense directly from them as well.
Much discussion about media comments and managing bad publicity. Do we understand, looking at all these documents that we've been looking at this afternoon in relation to remote access, that you were personally very involved in the remote access issue from the legal side?
If you're talking about which period of time are you talking about?
The documents we've been looking at, so let's say 2016, 2017 period.
Yes.
There was a lot of focus on the wording. A lot of care was taken over how that was presented. Do you agree with that?
Correct.
It was a significant issue for the business as a whole, Post Office, the admission.
I couldn't comment as to what they thought about it as a wider business issue. I can tell you they thought it was important within the context of the litigation.
And as we've seen, a lot of toing and froing and care taken over the issue of remote access in terms of how it would affect the litigation.
Yes.
Could we please turn to poll 00254632, please? Now, this is a chain of emails. I appreciate it's a document that you will only have seen this morning, but I'd like your assistance on it. Let's start on page 4, if we may. If we scroll down, please. Actually, if we go to page 6, just to have a look at how this issue comes in. There's somebody from Information Services called Eleanor Bradley on page 6. If we scroll up, please. Thank you. It is discussion about an issue that has been raised in a particular post office. If we could please turn to page 4 and the email from Jonathan Gribben to yourself. So Jonathan Gribben was a managing associate in your firm, is that correct?
Correct.
And I'd like to just read this email. He says, Andy, I've spoken to Sri. Now, was Sri the postmaster, do you recall?
I don't know.
I think it's the person who has at least raised the issue. And he has sent me the email chain below by way of further background. So in fact, Sri is from the post office. He is the lead branch availability manager. So he has raised it with your firm. In summary, post office have exhausted all other ways of cancelling this transaction correction. And I agree that there is no alternative but for Fujitsu to manually remove it. Some key points. The transaction correction relates to a redundant product that this branch never sold. Post office reinstated the product and gave the branch permission to sell it, but it was not possible for the branch to accept the transaction correction. Post office cannot issue another transaction correction to net the first one off for the same reason. The transaction correction was issued due to human error rather than technical fault. So just pausing there, a transaction correction has been issued in relation to this branch. The branch is a McColl's branch, so it's less likely that the claimants in the group litigation will become aware of the issue and get the wrong end of the stick. And in Sri's view, the real risk to post office is not fixing the issue, as it's preventing the branch from completing its trading period. The branch may have been incurring losses, and in the circumstances, post office is likely to have to pick those losses up. Are you happy for me to give Sri the green light to have Fujitsu remove the transaction correction? So there has been an issue in a branch. It's a McColl's branch, I think a chain branch, and it seems as though they are holding off asking Fujitsu to remove the transaction correction because of the ongoing litigation and the issue of remote access. Is that right?
Yes, that appears what that's saying.
And if we scroll up, we have your response, and you say, can they not settle the transaction correction centrally and then wipe it off the postmaster's account? Were you at this point qualified to be making suggestions as to how to correct an error in a branch's accounts?
I knew enough about transaction corrections that there were a couple of ways they could be processed through the system. Where it refers to a postmaster's account there, that doesn't mean the account on Horizon. That means the account at FSC.
And why are you getting involved in the minutiae of a postmaster's account?
Because it appears from the email below, and I have to say I don't recall this email, and as you said earlier, I only was passed it this morning. It appears from the email below that the solution being proposed is for Fujitsu to manually delete or remove some data. That's a version of remote access, it appears, and that's a very key issue in the litigation.
If we scroll up, we see Angela Vanderbogard. She says, no, I asked Sri last night when he rang me. The issue is that the branch cannot process the transaction correction at all. If we scroll up, we have your response. And you say this, I think we, the legal team, need to take charge of this process. Whatever documents are produced are likely to be disclosable, and I would like, as far as possible, for this to be covered by privilege or have controlled their content. 1. As a first step, I would like Sri to copy all emails on this topic, past and future, to Johnny. So Johnny's a lawyer, is he?
Correct.
Johnny, please then keep this somewhere separate and safe. He should then be instructed to take no further action for now. Second, I would like to escalate this to Pete and Torsten at Fujitsu so that they can produce for us a full and privileged note on what has happened and why there is no alternative but to editing the data. Third, we can then make a decision on how to proceed in light of the full facts. I understand that this is going to cause operational problems and risks in this branch, but if not handled properly, this could be disastrous for the group litigation. And doesn't this take us back to where we began today, at the very beginning, that your advice to the Post Office is let's blanket this in privilege. This is a technical issue with a branch, not a claimant's branch, just a random branch that is affected that needs a correction. And your advice is let's cover this in privilege because it could be disastrous for the group litigation. Just as in the very early years you were advising in respect of, for example, the notification to the insurer, let's not write that down, let's deal with it, cover it in privilege as far as we can.
I think in the context here, and as I've said a number of times, I think all of these decisions are context specific. We're in the middle of a large piece of litigation. An issue has arisen that is related to one of the key issues in that litigation. I think it's appropriate for any organisation to avail itself of legal privilege to investigate that issue. To be clear, that's not to say that the issue wouldn't be brought to light. I think it's possible for an organisation to investigate something under privilege and then to make decisions later when it has the full facts as to how that then gets disclosed through the litigation process.
But here we have hold off making that correction to a branch, unrelated branch, because of the impact on the group litigation. Do you think that was an appropriate approach to take?
I do think that was an appropriate approach to take.
Does it make any difference for you that the Post Office is owned by the government, by the taxpayer, in how that kind of litigation is conducted?
I still think Post Office was entitled to avail itself of legal privilege.
Final document I'll take you to today, it's Pol 00276195. It's an email from yourself to Ben Fote and Roderick Williams in June 2019. And you're explaining to Ben Fote about some of the history of the litigation and why an overall advice had not been obtained. I'll read the email. It says, the concern at the outset was that any early settlement would be seen as conceding the claimant's arguments on the sub-postmaster contracts and Horizon. This would then possibly open up the floodgates to more claims. So the plan was for the Post Office to try to secure some positive decisions in its favour before breaching the topic of settlement. The strategy was to contest the common issues trial because based on the advice from counsel, Post Office should win on most points. When the common issues expected to be resolved in Post Office's favour, either the claimant's funding would collapse or they might walk away for a modest settlement that, when viewed against a positive common issues judgment, would not set a dangerous precedent. With this in mind, before the common issues judgment was handed down, we had already agreed a mediator with Freeths and had begun planning for settlement discussions. Further, Post Office had Deloitte review the Horizon system out at the outset of the litigation, and they advised that Horizon was robust and extremely unlikely to be the cause of shortfalls in branches. This therefore gave us a backup plan in case the resolution didn't come immediately in the wake of the common issues judgment. Deloitte gave us a degree of confidence in winning the Horizon trial, and that might then cause the claimant's funding to collapse, or a modest settlement would be possible. If this didn't work, then the next steps was to thin the herd. By this, we meant identifying subgroups of claimants whose claims could be defeated on a technicality or legal point. For example, trying to strike out all of the time-barred claims. By thinning the herd, you undermine the economics of the group. Less claimants means less damages, which makes the funder's return on investment lower to the point where they would prefer to settle rather than invest more money. And it's this final paragraph, substantive paragraph, that I'd like to focus on. You say the strategy was never to seek an outright win, through the court process, for that would mean ultimately defending 500 plus individual claims in 500 plus separate trials, because the cases turn on their own facts and the utility of dealing with them as a group gradually erodes as more group issues are resolved and you are left with individual issues. Even if Post Office's legal case was perfect, securing a full resolution through the courts would take years and be massively disproportionately expensive. Hence the above plan to build leverage and air cover through the court process to force a settlement or collapse of the litigation. Does that explain the approach that you took to disclosure throughout these years? That you would never see a final trial, so no one would ultimately look under the various rocks that have been placed over these pieces of information?
No, I don't ever recall thinking like that.
Was it a strategy to delay disclosure of important documents, just like we saw in relation to that Amy Prime email that you inputted into? Delay disclosure until the moment at which you're becoming criticised, and then you can provide it. And if that strategy worked, you would never have to provide certain information, because the plan was never to hear the full trial until the end.
No, I think you referred to one outlier email, and if you look at the balance of the advice we gave on disclosure to Post Office, it was actually to err on the side of giving more disclosure and being generous with disclosure.
So that might be an appropriate moment to break for the day.
Yeah.
I have at most 1 hour left, and then we have questioning from court participants, which shouldn't be more than around an hour and a half, at most 2 hours. So we have plenty of time tomorrow.
Then that's fine. And I'd be grateful, Mr. Blake, if you just send me a rough breakdown of what we expect with the co-participants, so that I'm au fait of what's likely to occur, if you would.
Absolutely.
But yes, let's call it a day for today, and we'll resume again at 9:45 tomorrow.
Thank you very much, sir.